stroke PPO, the Freedom Fighters Division of Home Affairs shall, on receipt of a request from the spouse stroke unmarried dependent daughters, call for his or her verification report from the district magistrate concerned. After receipt of verification report, such case will be proceed as phase 1 and necessary sanction addressed to the Chief Controller of Accounts, Ministry of Home Affairs for issue of fresh PPOs. Well, here also, no time was prescribed.
Yes.
Then paragraph C of that page, where pension has been sanctioned to a freedom fighter before 1/1/90 and the freedom fighter has since expired before or after drawing the pension for some period, and where the name of the spouse was not included in the sanction letter stroke PPO, the Freedom Fighters Division, Ministry of Home Affairs, on receipt of a request from spouse unmarried dependent daughter, called for his verification report from the district magistrate. After receipt of the verification of such letter, will proceed afresh as a one. Here also no time limit was prescribed. Then you will see, can escape over to page number 24.
Yes.
24, without paragraph 1B Roman I. In case of pensioners,
list of dates. Yes.
already drawing their pension through the public sector bank, director of accounts, treasuries, pay and accounts officer, payment of family pension, as indicated in the pension payment order, shall be commenced by the disbursing officer on receipt of the death certificate and application for family pension in the prescribed form, along with pensioner portion of pension payment order. The disbursing officer will enter the date of death of the pensioner in the disburser portion of the pension payment order. Also make entries in the pensioner portion of the pension payment order before commencing payment of family pension. The disbursing officer will take action for identification in the family pension as prescribed in the rules. The date of death of the pensioner will also indicate to the Freedom Fighters Division, Ministry of Home Affairs, such and such, such and such. Here below, no time limit was prescribed. In simplification of the procedure, the time limit was not prescribed, but it prescribed I am to apply before the bank. Bank will take this and such and such.
Where do you find bank?
Bank, but disbursing bank. Accounts officer payment or payment, the public sector bank, the second line.
All right. Yes.
Yes. Somewhere it is through bank, somewhere it is from the treasury.
Yes.
But it was simplified. But it was never prescribed any date.
So what was the simplification?
Simplification, how the transfer of pension will be made. That was the simplification as prescribed here. You also can see the page number 24, new scheme for payment of freedom fighters pension with effect from 1st of January 1990. Simplification of procedure, amends regarding. This is the heading of the notification.
Yes, now come to the point where the time limit was prescribed.
I am coming.
That is your argument.
I am coming. Lord, Your Lordship, I put not the bulky one, I have not annexed. Your Lordship, take pain to come page number 169 of the paper book. 169 of the paper book. 169. This is a scheme, my lord. This is a guideline to the public sector bank. My lord, first of all, Your Lordship, can you peruse the 162?
So your argument is, though under the scheme, there is no time limit prescribed for an unmarried daughter.
Prior to Scheme Act, page 162.
Yes.
Which is, according
So
to me,
where-
and my lord, according
So
to
this where there was no period for application, that right of mine cannot be taken away by virtue of this guideline. This is your argument.
yes, sir.
All right.
That too, first of all, this guideline, which my lord sitting in the division bench also held, this guideline is not applicable in the scheme of 1981. In the Sadhana Bala's case, in paragraph 5. I will take to that a bit later on. Now, my lord, I am accepting that guideline is applicable. Let us take for a moment that the guideline is applicable, is accepted. My lord, page 62, your lordship find this is a guideline. This is 162.
Yes.
This is a guideline for disbursement of central Samman pension to be followed by the authorized public sector bank.
Yes.
This is neither an amendment nor a corrigendum to the scheme, but this is a guideline to the bank which is to be followed.
Yes.
My lord, kindly take pain to come 169 for a moment of that scheme, guideline. Not scheme, not guideline.
Yes.
Paragraph 5.2. Transfer of pension to spouse to daughter. Sorry, my lord, in my brief it is written 168. My lord, I'm sorry, Lord, it is 168. No, sorry, my lord, 168, my lord. 168, 5.2.
5.2.
2.
Yes.
After the death, what I am reading, my lord. After the death of the pensioner, whether freedom fighter himself or his spouse, the transfer of pension to the spouse stroke daughter will only be considered if she applies for transfer of pension within 6 months of the death. That is, my lord, if within
Understood.
6 months it is applied to the bank will automatically transfer. But next portion. Application received after 6 months shall not be considered by the bank, but refer to the ministry. The ministry shall then take a view whether to allow dependent pension or not, or whether any arrears are to be paid.
Yes.
But here I like to submit before lordship, the time limit was prescribed for the bank. If the application of the dependent daughter be made to the bank within 6 months, they will transfer, the bank will transfer the pension to the dependent daughter. In case of the application by the dependent daughter beyond 6 months, bank will not touch it the same. Bank will refer the same to the ministry, and ministry will decide the matter.
Yes.
But here also, within which time the application before the ministry is to be done is silent.
Yes.
Lord, then your lordship kindly skip over the next page, 169. Clause 5.2.2.
Yes.
The dependent pension shall be paid from the date of the application by the spouse or daughter and not from the date of death of the pensioner. Because here I like to submit, if there would have been a time limit.
Understood your point, Mr. Panda. You don't stop at every juncture. Now tell us, you make the final argument. You show us the provision, make the final argument.
Yes. I. Then what a 5.2.3.
Yes.
What I am to whether I'm trying
So
my
we
level
are
best.
saying you take us through the provision, then you advance your argument.
Yes. But I
Stop at every clause.
5.2.3.
Yes.
The spouse daughter must fulfill twin conditions of being unmarried and having no independent source of income. They have to submit two certificates as are Annexure 6, Roman 6 and Annexure 7 to the bank every year. That is regarding the life certificate and such and such. Then your lordship kindly come to page number 170, 6.1.2.
Yes.
The bank must ensure that a dependent pension is not sanctioned to a spouse or a daughter of a freedom fighter if the spouse daughter is already employed in a central or state government, central or state PSU or local body. In case of the spouse daughter is working in a private sector or having his or her own business activity, then the income from such job stroke activity exceeds rupees 20,000 per month. This is the Devara, I will not. As I have restricted firstly on the point of the limitation, I straightway like to draw my lord's attention to the last annexure which I have handed over here. Sorry, my lord, not last annexure. It is annexure, my lord. It is annexure. But I'm just telling you. It is J at page 36.
Page
Page 36.
of your compilation. Yes.
Page 36. This is the of 10th October 1924. So specifically, I am drawing my lord's attention to page 39.
Yes.
Here the time limit has firstly been prescribed. Claim of those spouse and unmarried and unemployed daughters for dependent pension will be considered only if it is applied within 3 years of the death of original freedom fighters. Now in 24, this time limit has been prescribed by the Ministry of Home Affairs. And it also been stated this will be applicable with effect from the date of this issuance of this notification. Paragraph 5. The above amendments shall come into force for all the applications received on or after the date of issue of this order.
Yes.
So, my lord, save and accept this. No time limit for consideration by the
All right.
government was made.
Understood. Yes.
That too, I have also annexed some documents here, wherein after 14 or 16 years, application was made and sanction has been given to them. I have annexed those. At least 2 judgments I have annexed here in the compilation. In the first one, it is in the case of my lord Olokabera. Her daughter, her husband, father died before below 90s, that is at about 81,
Which page you are referring?
page 40. Compilation. Well, it will be
No, no.
evident from
Was this a point taken in your appeal? That discrimination point you have argued that in respect of others it has been given, but it has not been given to me. Then, Mr. Manna, how can you take us to those documents?
So there was, I took that point. Others point I did not take. I took the point there was no limitation. So limitation
Yes.
cannot be taken. I took that point.
No, no, that we understand. Now, you are arguing a point of discrimination.
That is the subsequent. Subsequently that has come. So I have.
Show us that page only. Show us that page only. Where discrimination?
Is the where discrimination? Discrimination is you also kindly have a look to page number 40. 40.
Yes.
Where I will say show that the father died in 1981. No, died 80. He did not even apply. Then made a writ application in 2007. That was directed to be considered. And subsequently, the pension has been sanctioned from the date of the application, from the death of the father. So there was no limitation, but they did not do.
That was he made the application, it was not considered. He came to the writ court, he obtained a
No.
direction for consideration.
Here, no, application was not made. He belonged from the writ application. I will show there is no application. In 2007, they come to for the first time to the court. In the cause letter, the application dated nil. No application was annexed. I got that copy with me, the writ application. Then the writ court said, consider this writ application as a representation. And on the basis of that, consideration was made and payment has been made from the date of his application.
That is unmarried daughter. All right, you come to
And
your
then
case.
also another matter.
No,
at
please
page
now come
48.
to your case. You show us what is your case.
My case is, I have submitted only to the effect of limitation. I have not submitted anything as regards the income of my applicant. If your lordship satisfied with the point of limitation, then I will take the other point. Otherwise, unnecessary course time will be.
No, you finish it off. What is your next point?
Next point is,
yes,
I was not
when was the death of your father?
My father's death is, my lord, 1996. My lord, 18th of February 1996. I have annexed the date. I have also prepared a list of dates. Your lordship so determined, I can hand it over.
Yes, you have given to us.
List of dates I can give.
Yes, 18th of February 1996. You submitted.
My father died.
Yes.
And I applied on 19th of June 2007.
Yes.
But a reminder was given 2007, and audit officer requested the authority in 2007 to examine the case. But then representation was made, nothing was done, a writ application was moved before this honorable court and directed the authorities concerned to decide the application of the petitioner. On the basis of that, the rejection order has come on 7th of August 2012.
Yes.
Especially on the basis of the DIB's report, petitioner was in regular employment from 79 to 2007.
Yes.
I made representation against them, and ultimately they also rejected at page number 60, and then I moved the writ application.
তাহলে পয়েন্ট অফ ডিসক্রিমিনেশন আপনি রিপ্লাই করলেন যে পরবর্তীকালে ওরা সব অ্যালাউ করতো কোর্ট সেম রকমই জাজমেন্ট পাস করছে কিন্তু সাবস্টিটিউট আর সেটা ওরা এও করে নিয়েছে পেনশন আমারটা আগে হয়েছিল তারপরে আমরা অ্যাপ্লাই করেছি কিন্তু ইনলাইমেন্টে করে গেল
Yes.
Lord, then the writ application was moved. Lord, the writ application is the impugned before my lord. The writ application mainly dismissed on the ground of limitation. Lord, writ
And
application
you
is
had and you were engaged in private sector.
private section, honorarium, not salary. It was 25 started in
Mr. Manna, kindly visualize the conduct.
Yes,
Let us know.
yes, yes,
Her father expired in 96.
96.
She started serving in private sector. So she continued to serve till
Up to
2007.
Up to 7.
Now your father died in 1996.
Six. Yes.
After the death of, after having served in private sector, then you made an application with a permission to get the pension.
So I am asking myself, as to what amount I was getting? 25, 50, maximum 600 something.
Good, bad, indifferent. You were in earning 79 to 2007. You were
Correct.
there.
Scheme says, if I get more than 20, I will not be entitled.
Pardon?
Scheme says, if my income goes beyond 20,000 per month, I will not get. If I can prove that my income was much below the 20,000, I am entitled.
You have consciously not approached this. You could have done so in 1996. You took the choice to continue in a private sector, inviting the
Actually,
that you will have to prove again that 20,000 I did not earn, I earned 5 rupees. Why the court will exercise? Writ court is a discretionary relief is to be given to you.
in fact, I was in Assamik. I was in the Gandhi
Mr.
Ashram
Manna, you
since
have
1960.
there is no explanation why you did not apply after 96 till 2007. There is no explanation.
In the application, I don't find any explanation.
Then, Mr.
But I am to be very frank to my lord.
No, we understand you're fighting for a pensioner. We understand that. But kindly visualize this one thing. Apart from the intricacies of law, let us visualize. This is Samman pension.
Yes, my
It
lord.
is in acknowledgement of the
Freedom.
activities of the
Sacrifice of the father.
my father. Now, my father was a pensioner. I was admitted facts. 96, my father died. Then you must have thought that whether I will apply for pension, then I may lose the job. So you took the choice that let me continue with the job. You continued till 2007. Suddenly after 2007,
For accepting my lord's views. If I say in this way, till 2014, there was the scheme says if unemployed, I will not get. In that event, up to 7, I was employed in a private sector.
now you
In
lost your
2014, in 2014, it comes that no independent income will be treated as above 20,000. Then I can apply. And here also scheme says where it has been also stopped about the self-income, that will be revived. That will be again given the areas. Lord, the scheme was silent on that day. What is the meaning of the independent income? Commission থেকে judgment গুলো দেওয়া আছে। 168.
পাবো।
সরি
Transfer of pension.
কি দেখাচ্ছে? On the point of law একটা আছে না, সাবমিশন অন ল একটা রাখতো, এটি নাকি
এইটাই
এইটাই তাহলে পুরোটাই হবে। এটাতে কোথায় এটা?
ট্রান্সফার টু রেভিনিউ ট্রান্সফার আমি কাকে করবো কিন্তু আমায় বললে তবে তো
ডাকুমেন্ট পুরো জমা ও এই যে
হবে না ট্রান্সফার once of the duty applies at the date of pensioner, in transfer of pension will to transfer of pension মানে যে পেনশনটা পাওয়া হচ্ছে,
ফ্রেশ অ্যাপ্লাই করতে হচ্ছে।
সেটা তুমি স্ট্রিক্টলি কি বলতে পারো যখন হচ্ছে তোমাকে apply
করেছি সেটা বলছে অ্যাপ্লাই ফ্রেশ to be considered as a fresh. You shall have to apply afresh with proof of death of the petitioner and their considered in the scheme. Page 25. With the page 12, it's a page 4.
except in the case of another pension is for lifetime of the in case of cutted. In the case of death of heirs, though otherwise eligible for pension, will not automatically succeed. They have to apply.
That's right. Like
But ঠিক আছে
that you know to 6 মাসের টাইম limit, whereas you fresh apply করতে পারছি
এটাতে ফেল করবে
টাইম লিমিট
সেটা minimum for a pension
Like here in this bunch, can we produce this or
Again,
produce this?
yes.
Paragraph 18.
What is he referring to? Nothing is given to us.
My lord, perhaps my learned friend has not gone through. On the last day I have given.
Page 14, what is
I have last day.
Precedent. He's referring to a judgment or a single judge.
I have on the last day I have given you the bunch. Kindly have a look.
Mr. Manna, give.
Well, I am giving another copy. My lord, there is no question of
Which
what.
paragraph? Which paragraph?
Paragraph 18, my lord, first year, 18, 90 and 20. আছে দিচ্ছি কাঞ্চনমালার জাজমেন্ট তুমি ছিলে সেটাই my learned friend appeared in that matter also my lord. Oh no, sorry, Chanderi Alam was there. Paragraph 18, 90, 20.
Mr. Beck. 23. Subsequently, this point was not allocated.
এটা কোনটা আগে আগে ইউপি অর্ডারটা আগে না এটা পরে কোনটা আগে হয়েছে কাঞ্চনটা আগে হয়েছে
আমাদের 4-10 এসেছে আর এটা
Unfortunately, my lord, the impugn order passed prior to this order.
13 ডিসেম্বর পাস হয়েছে এটা আর আমাদের 4-10 4 অক্টোবর আর 13 ডিসেম্বর
এর জাজমেন্টটা জানো জর্ষের জাজমেন্টটা জানো কাঞ্চন এটা সাধনা বলা খুলে দাও খুলে দাও
আপনার
পাঁচটা দিয়েছি আমরা চিন্তা তো দিয়েছি
হ্যাঁ তো আছে তুললেন ফেরত দিলেন
How this is in your favor? This is also subject to an application.
Yes, I have made application.
Hmm.
There was application in 2008. Died in 1997. In both the matter, my lord, I had my good luck to appear before the court, my lord. In both the matter, in Kanchan Burman and also in Sadhana Bala. One,
Yes, Mr. Chakut.
my lord, that too, my lord, another judgment of my lord, sitting with my lord Justice Matre, wherein my lord held the guideline of 1940 is not applicable in the case of 81 scheme. My lord, in paragraph 5 of the judgment, my lord, your lordship sitting with my lord Justice Matre held in paragraph 5. না ভাইলাল ভাইয়ের কথা তোলেনি এখন
Which paragraph? Yes? Which paragraph?
paragraph 5. Paragraph 5. Shall I read, my lord?
Their application was submitted. Their application was submitted, which was sought to be debarred on the ground of the guidelines. But in this case, there is no application.
I have applied in 2007 here.
In this case, here, in this case, there is no application which you made from 1996 to 2007. Your only argument is whether when there is no time limit for application, whether on the basis of a guideline, my right can be denied. This is your argument. So let us hear on that point.
But on the point of your earnings, your lordship, Madras High Court has given a judgment. Well, wherein, the meager income is no part. It has been held. I have given the at page number 8 also. I-
This way, how he can argue? Then we have to again adjourn.
No, my lord, I have not completed.
No, he will
Only
take
two judgment I will
this
refer.
judgment. You have to give copy. Other judgment you have to give.
I have given copy, other judgment. Each and every judgment I have given. I am not in the habit to not to give to the other side. But
Which
this
other
copy-
which other judgment? You please
The judgment
conclude.
has been annexed
Please
in the
conclude your hearing.
Yes,
Conclude your
Yes.
hearing.
here also, my lord, I have annexed page 6 of the last month. In the case of Kohima Bibi, Rahima Bibi, and the comparison, last comparison I have handed over.
What
At
to be the
page
compilation?
Enclosure A1,
Page?
page 6, enclosure A1, my lord, paragraph, my lord, 4, relevant portion at page 8 of the last comparison which I handed over to my lord. My lord, the heading of the compilation is submission on behalf of the applicant. Appellant, sorry, my lord.
দেখো তো পাও কি?
I just now I haven't.
Disturbing হয়ে যাচ্ছে।
ওইটা যাওনি নাকি? ওরা দিয়েছো?
দিয়েছিলাম, ওনারা বললেন না আছে।
No, no, I don't know, my lord's court officer said that it is there. এটা দিয়ে দেন না জোসেফকে। আরে ওটা দিয়েছি রে দাদা, আপনাকে দিয়েছি, দেখুন দাদা, ওই তো দিয়েছি, দেখুন না, ওই তো বাঁশটা দিয়েছি। হ্যাঁ, আরে দিয়েছি, একটু দেখুন না। হ্যাঁ হ্যাঁ, ওটা এনক্লোজার A1, page 6, relevant portion at page below 8, paragraph 4.
Yes.
It is with regard to the income. They complied with the order from the date of the application. Again, read application was moved.
Please place
No,
me
I
what you are
speaking on page 8.
what you
Page
are
8, paragraph 4. It is to be noted that the grant of freedom fighters pension is as per scheme formulated by the government, which has a statutory force, and the entitlement of pension is as per the scheme. Merely because the petitioner is receiving a small honorarium sanctioned by the state government on account of having become widow at a young age cannot be a ground of rejection of the petitioner's application for family pension under the Freedom Fighters Pension Scheme. Here the proposition I would like to make.
চলে আসছে।
টা কত পায় সেটা কোথাও বলে?
20,000 টাকা।
সেটা কিছু বলে না।
How much were you earning?
I am earning,
Show us the order which was dismissing your claim. Page in the paper book, which page?
impugned order is a page 63.
Not the impugned order that you are earning less than.
Oh, yes. 56. 56.
Of the paper.
এটা তো but it is 100, last paragraph 2 of the page 56, at the rate of 150 per month.
50 per month is that pension amount.
তারপরে দেখা
The pension amount is 150, Mr. Manna. The pension amount is 150.
No, I don't have any pension.
Where is the order rejecting your claim?
Sanction, যেটা স্যাংশনটা
Madam, other sanction was in 90.
আমার রিজেকশনটা চাইছি না।
My rejection was initially, Lord, it was rejected, firstly. Disturb চেষ্টা করে গেল। Lord, my first rejection was, my Lord, reminder or sorry, my first rejection was, my Lord, 7th of August 12 at page 56 of the paper book. এটা কি রিজেকশন অর্থ দেখাচ্ছিস?
হ্যাঁ,
আমার ইনকামটার কথা বলছিল।
কখন এটি ইনকামের পয়েন্টটা নেন, কখন
আরে আমাদের ইনকামটা কোথায় দেখাচ্ছে? বার করো না, সেটা কোথায় আমার বলছি আপনার।
Yes, show us that. Show us how much were you earning.
আমাদের আর্নিংসটা
কোর্ট বলছে যে হাউ মাচ ইউ আর আর্নিং, তাহলে সেটা হচ্ছে
আমাদের
আমাদের
আমাদের পিটিশনে বলা আছে তো।
হ্যাঁ, দেখ, আমরা অ্যানেক্স করেছি
কোথায় সেটা করেছি?
114
Well, my income I have stated, I have annexed at page Milord
40 starts from 114.
114. 114 of the paper book. It is my income, certificates of my income given by my employer.
এটা হচ্ছে 79 এ স্টার্ট হচ্ছে।
It was in the year 1979 at the rate of rupees 71, then additional dearness 26, including 187. Last page.
136 or last page 136
আমি তাহলে
136
আমার চলতে যখন করার উচিত ছিল 96 ছিল, তখনও তো এসি, তখন তো সিচুয়েশনটা তো বেটার ছিল, দেয়ার ওয়াজ নো টাইম।
তারপরে আমি যাই, কিছু পাচ্ছি না, সেটা অ্যাপ্লিকেশন 2007 অ্যাপ্লাই, 8 অ্যাপ্লাই করবো, এটা করেছে 2007, সেটাই সবগুলোকে হোল্ড করেছে। ক্যানট বি আ মিয়ার কোইন্সিডেন্স। তোমার সব কোইন্সিডেন্স একটা জায়গায় বলেছে। Immediately after retirement.
রিটায়ারমেন্টের পরও দরখাস্ত করলো, সেটা কনসিডার করতে বলে দিল।
Petitioner was clearly seeking to take a chance after having retired from a job.
ইয়েস,
Lord, last requirement salary was at 136 at the rate of rupees 7,934. When I retired, at this amount I retired.
Per month.
And from 114 to 136, I have given the whenever increased.
page 136 is a memo of 1969.
No, paper book.
ওর নিচে আছে
Your Lordship, can you see?
ট্যাবুলার ডেট নেক্সট
Your Lordship, can you see the next date? Tabulation date of 7th of January 2012.
Where you are saying?
Page in Milord 136. Date was first date, Your Lordship, find 25th April 1964.
Registration.
Then the tabulation date is 7th of January 1912. Amount shows, Milord, retirement done on 31st March 2007. Her monthly salary at the time of retirement from service was basic pay 2,750, dearness allowance pay 5,005, special pay 179, total 7,934.
Yes, Mr. Chopra.
No, it's today is not possible. He has argued something which is not pleaded in the writ petition. He has argued something which was not the subject matter. The question of his argument, if I am to answer to the doctrine of par inquinium, obiter dictum, and all those questions will come into force. And the Supreme Court has categorically stated that in respect of freedom fighters pension, court will be very slow to grant such pension? These are the questions I'll be arguing. Kindly fix any date convenient to your
We
lordship.
want your answer on only one
No,
point.
that apart, there are other questions.
No, other questions was neither before the
Lord,
trial or not before.
actually, he has not been able to convince your lordship under which scheme he actually falls in. 72 or 80 or 2014 or 2024. These are to be distinguished.
1996. He died in
1996, days of the father.
Right. So it must have been prior to 1996. Scheme which was relevant.
That apart, the
No,
question.
we wanted an answer from
Yes,
you.
I shall answer. Consistently it was held that the question of
So Mr. Manna, learned advocate appearing for the appellant, has concluded his argument.
July your lawsuit had been placed to fix.
এটা সকাল থেকে যখন ঠিক আছে বুঝতে আপনার ওটা টাইম কি বলবেন সকাল
But I am for the appealing one.
For the respondent.
Determined ক্ষেত্রে সময় জজমেন্ট Yes,
You have to kindly see the order dated 7th August 2024. Well, the gist of the points was recorded in that order. 7th August 2024. Well, may I place that order? From paragraph 3, my lord. We are satisfied that the case involving certain question of law is to be decided, and more importantly, the maintenance of the writ petitions challenging a demand raised by the railway for detention charges of wagon as well as the diesel engine charge.
stay application নিয়ে সব চলে যাচ্ছে এই অ্যাপ্লিকেশন স্টেজে আমরা তোমাকে ঢুকে যেতে হবে মেইন
My lord, may I place that order? My lord, paragraph 3, my lord. We are satisfied that the case involving certain question of law is to be decided, and more importantly, the maintainability of the writ petitions challenging a demand raised by the
you have
railway.
filed paper book you have filed
No, my lord, there was no direction for the filing paper book, my lord.
affidavits have been exchanged in the stay
Friend
application.
decided not to file. My lord, friend has decided not to file the opposition, my lord. There is an order of this bench.
Opposition, they have filed the opposition, we have to be filed, my lord, reply. My lord, I think, my lord, there is no necessity to file any reply, my lord.
There is an order recording that they have declined
Yes,
to file
that is already recorded in your lordship's order.
of 9th June 2025.
Yes,
My lord, kindly see that may I place that, my lord, that order dated 7th August 2024, my lord?
why you are not filing a paper book?
My lord, if your lordship direct me, so I have to file, my lord.
Because it is very difficult, na? Opposition, stay application, writ petition enclosed. We don't know what are
But,
the pleadings exchanged.
in my lord, the stay application, my lord, we have annexed everything, my lord.
In the writ petition was on affidavits.
They did not file opposition
is
in the writ petition also. At the lower court proceedings also, my lord, they chose not to file an opposition.
In the before the writ court.
Yes.
But your opposition is on record.
I was the writ petitioner. I
They
succeeded.
did not file any
No.
opposition.
They have filed their affidavit in opposition against the stay application.
Here
before the
we have filed in
Mr. Ghosh, you enclose and file a paper book. Na? Your writ petition,
Yes, yes.
the affidavits in the stay application.
Informal paper book, my lord.
Informal paper book you file. You know, you know.
ডিসক্লোজ করেছে সিভিলের কাছে ওগুলো ছিল না
ও opposition.
অপোজিশন দেয়নি রিপিটিশন ওটা কথা বলা হতো। রেসপন্ডেন্ট অ্যাপিয়ার করছে কি না? পুলিশ করে দেবে না কেন? Continue.
একটু ওই আগের ফাইলটা দাও তো একটু, আগের ফাইলটা। এই যে
না,
যেটা
এটা-
অর্ডার
5 নম্বরটা। ওটাকে স্টে করে দেবে।
order direction issued by single judge shall remain strict.
এগুলো যে টাকাটা ডিপোজিট করা আছে ওটা ডিপোজিটই হয়।
Then
বুঝছো? এখন যেটা হলো, সেটা আমরা সঙ্গে কাজ করি, কিন্তু স্টে হয়ে গেল। ডিরেকশন ইস্যু করে শ্যাল রিমেইন স্টে।
সেন্টারকে খুলে ওই টাকাটা দিয়ে
Not the appropriate authority.
Like COVID for refund.
আর সেটা স্ট্রিক্ট।
Further action present.
Yes,
But I am appearing on behalf of the appellant petition in this matter.
For
But,
the state here.
May I be permitted to file this affidavit service.
For
The last time when the matter appeared with your lordship on 25th, your lordship's direction was to give notice to the private respondents, and Mr. Sengupta's junior appeared on the last occasion, and your lordship directed, or your lordship advised that Mr. Adak, learned advocate who enters appearance on behalf of the state respondent, is directed to avail the necessary instruction. My fate hinges on the instruction if yes, my learned friend has obtained from the bailor.
Hmm?
My fate hinges, my lord, on the reports to be submitted by my learned friend, if he has come with the report. Because lordship sees the order, order dated 25th of June. Mr. Adak, learned advocate, in spite of the service, no one appears on behalf of the private respondents. We have served the private respondents. The learned advocate appearing for the private respondents before the middle of the learned single bench. Pursuant to Lordship's order, copies have been served, information given, and Mr. Adak, who represented the state on the last occasion, was directed to avail the necessary instruction. If my learned friend has obtained any instruction with regard to the my lord, the actual state of affairs of the land which I am owing, my lord, I am the bona fide purchaser. My land is there. There is some encroachment. If my learned friend submits the report, then everything will be clear.
My lord, please take us to the order.
Yes, your
Which
lordship.
order you have challenged?
My lord, I have challenged, my lord, the
Order dated
Yes.
26/9/2023.
26th of 2023. Lordship, may kindly see page 61 of the application for stay. Yes.
Yes.
Lord, my humble submission before Lordship is this, Lord. The matter can be disposed of by your Lordship. Simply, my submission is that if the BLRO concerned submits the report, but there is any encroachment upon my land, or there is no encroachment, the matter ends. If he comes with a true report that, yes, this is the report from the BLRO, that your land has not been encroached by the private respondents, the matter ends. Private respondents are here or not? No. Private respondents are being represented. The Lordship's specific direction was to serve the copy or the information to the private respondent, and the report note of the BLRO will play an important role.
May I just
Because-
indicate?
You say what is the wrong with this order?
Lord, wrong with this order is the thing, Lord. I am submitting, Lord, that the learned single bench wants to relegate the matter to the civil court. Your Lordship has wide experience, Lord, that once the matter goes before the civil court, the title suit, then title appeal, then the first appeal, then second appeal, then years, decades will go on. And I shall remain deprived of the my land, the fruits of my land, because I am the owner of the land.
You have to take possession of the land, na?
I am in the possession. I have the possession. But the thing is, a part of my land has been encroached. That is the report. What is the problem in giving the report? There is
So if the report comes that there is an encroachment,
then I will.
then also we cannot pass any order.
No, your Lordship will not pass. Your Lordship will pass the order accordingly that there is no encroachment. So Lordship
How can
dispose.
we decide encroachment or no
Just a
encroachment?
minute. It is not a matter of laughing.
Please
It is the
Take your seat now.
it is the question of early disposal of the matter. If the BLRO submits the report, an impartial report, that yes, this is the report, I have inspected the local and I have found that there is no encroachment made by the private
Did
respondent.
you make any prayer to the BLRO to that effect?
Lord, I have made the representations. I stated there.
No, show us any
Yes,
representation.
I have
you
made the
submitted.
representations, Lord. Give me the copy of the report. BLRO is a party, my lord. Reader copy লাগিয়েছে kind of reader copy yes read petition, yes, lord. That is a reader copy, madam. Oh, wait. But copy of the requisition has been annexed also. Paragraph 8, your lordship may kindly see.
Paragraph 8 of
Yeah, 8 of the requisition, page 21. Page 21 of the application for stay. In spite of receipt of the said letter of complaint, the respondent's authorities did not take steps against the said private respondents who illegally and wrongly occupied the said land of their premises and constructed a pakka and kacha structure thereon. That the respondents, in spite of receipt of the letter of complaint dated such and such, did not take any steps against the private respondents 69 for their illegal and wrongful activities. Your petitioners and advocates notice. Also, everything has been done. I have exhausted all the forums. What more I can do? I could not afford the luxury of litigation that I will file the title suit, then I come to the second appeal and this and that.
your cases, you are the owner of a
I'm the
plot
owner of the
land.
plot of land.
Now you are alleging somebody else has
Some of the private
encroached.
response they are making, they have made
Is
illegal.
that a government land?
Yes, it's not a government, it's my own land.
So then, Mr. Rai, how can we say?
No, the thing is, Lord, if your lordship kindly sees, I have annexed a copy of my deed, everything is there. If my London friend submits a report, Lord, that yes, it is, there is no encroachment, I am nowhere. Lord, I will go off. If they submit that, yes,
So
there
they
is.
have already said they have not encroached.
No, they have, let the BLRO submit the report. Let the BLRO submit that. BLRO has not said anything. BLRO is a party before the writ court. BLRO has been made a party in the writ petition. If the BLRO, I don't try in my humble submission, but I'm trying to pursue your lordship, that if the BLRO submits the report, where is the bar? Where is the impediment on the part of the BLRO to submit the report? That case, no, your allegations are not correct. There is no encroachment. Nothing.
Mr. Rai, BLRO has no obligation that we can understand. Have you made a representation to the BLRO?
It is representations have been made.
Wait.
Page 33 and except P4 of the application.
Page?
Yes. Page 33, your lordship kindly see.
Page
Page
33.
33. Page 33, so P4 of the application for state representation is there. Otherwise, I would not
We
have.
are not getting that.
We are not.
Page?
Application for state lordship has got
Yes.
page 33. It is just.
Don't give us, you tell us that is with us.
Page
Which
33
page?
from my
Page
application.
33 is a blank page.
Blank page P4. P4 is there. Equal.
One notice, but it is page 46.
ঠিক করেছে তো ওকে কি জিজ্ঞেস করছো তুমি নিয়ে এসো না আচ্ছা পেজ 50 তো আছে এখানে পেজ 34 33 কেন দেখাচ্ছ হ্যাঁ পেজ 50 হলো অশেপ
বুঝতে পারছি না ওরা against এ যাবে
wrong pagination is done. Page 50 Roshit Malkan, excuse me.
Page?
Page 50.
55.
50. I'm extremely sorry, Milord, that I have been misled because pagination has not been done properly.
Not
P4.
55. Your representation page 48.
48, yes.
Starts from 46.
Joseph ঠিক বলতে 46 থেকে আছে Don't compare the advice of the junior. She, See yours.
Yes, what you are saying.
My lord, two things. First of all, the prayer, if your lordship kindly consider. Prayer of the writ petition, if your lordship kindly consider. This matter has been filed in the Group 9 Police in Action. Now, the police is there to look after the complaint and the peace keeping manner. Now, the BLRO, even though party, my lord, this group, it cannot be coming under the Group 9. That apart, if your lordship sees the judgment passed by the Supreme Court, my lord, 2019, may I just hand over?
What is your instruction? What is your
Well,
instruction?
instruction of as
Police.
the
that
police
is-
cannot ascertain the who is the owner of the same, my lord. We have done the
Leave
120
that upon us. Leave that upon us.
No, that is of course.
So what is, you said that I will come with a report. We have recorded in our order. What have you done?
So the report is here, my lord. I can
Yes, what report?
I just
We passed an order on 25th June. What is the report you have?
my lord, kindly give me a moment.
Citizen complaints to you that somebody is encroaching upon my land. Civil dispute, we will decide. We will send them to the court. But let the police, what is the police as a, what is, they are, yes, you are for the private respondent.
Yes, my lord.
Report
So you are having constructed anything?
No, my lord. That is not that is not.
Are you raising any
Yeah,
construction?
it is-
Are you raising any construction?
No, my lord. That is not on his part. Not on his part. I have.
You have a sanction plan for your construction.
That is a normal kacha structure on the part of a roadside, my lord.
So that is your land.
No. That is
Then-
PWD.
Then
If
is PWD land, what permission you have taken to raise construction?
that I have to take some instruction, my lord, on that part.
You said that you are making construction on your own land.
Movement article.
That is your, to show us that it is your own land. Where is your deed?
My lord, that I have not been
Then,
obtained.
sir, then you are making construction in somebody else's
But
land.
whether there is a construction or not, that I have to ascertain from my client, my lord, kindly.
Just now you said that.
But my lord, let it be
You just said that you're making some kacha structures there.
on their allegations, my lord. On their allegation from the brief, I have said that they have made an allegation that I have made a kacha and park structure on the part of the land on.
We want to know that what is where you are construction-
Let me come back on that instruction, my lord, whether I have made any structure or not. Let me come back with that.
You are the adjacent owners.
No,
my lord, I have forwarded the report,
that
my lord.
is-
Kindly have a look into that, my lord.
not the adjacent owner. He is nobody. He has made such a
Two copies of the
construction that
report I have
that
handed.
obstructs my ingress and egress.
24.
I'm sorry, my lord.
Passed an order on 25th June 25.
March 24. What, Mr. Sengupta?
কোনো order অনুসারে কোনো report আছে? Is there any report?
You go to the site, find out who is raising construction. Civil dispute, go to civil court. Why they will go to civil court? We want to know.
My lord,
Your police is with him.
my police.
Yes. That is why construction
My lord,
going
may
on
I-
PWD land.
No, may I just put the question to myself, my lord. Lordship is
Police
told that
is,
police is helping him.
must be, because the otherwise.
That's the
he-
allegation and that is the presumption.
Yes, because for this reason,
Yes.
when we are asking you what is your report, you are showing us a report which you obtained sometimes when the writ petition was pending.
No, it was in a mat.
You ought not to have forwarded this to us. This is disobedience to our order.
My lord, possibly, my
Huh?
lord, with deepest
But
respect, my
your
lord.
police was sleeping. Did you communicate this order to them? Did you avail instruction
My lord,
from?
possibly on that score, on that the lordship is pointing out. Possibly on that day, I was not appearing, my lord.
Your name appears in bold letters, Mr. Suman Sengupta.
Then it is my fault. I have to take instruction. But so
Yes.
far, yes, I take the responsibility, my lord.
Take the instruction.
Yes, I have to.
Everything, people's life and property
But my lord,
We
the
will send him to civil court, but after your observation is recorded. We will send him to civil court.
my lord, this is also possibly, if your lordship,
This we will not see.
no,
This
this
is
is
March
also
2024.
this is also whisper of the same, whether they have done it or not.
Are you coming with the instruction as regards, tell your officer in charge, who is officer? Do we call him?
In charge, Tom call PS.
So do we call him?
Yes.
He's so reluctant to give
But
us
I am here to assist your lordship, my lord. It's I took the responsibility, then
Lawlessness is prevailing in the district of Murshidabad. I am bound to say that.
Mr. Rai, don't.
My lord, I'm sorry. I'm
Take
sorry.
your
I'm sorry.
I thought lordship would be
Mr. Sengupta,
like to see the judgment passed by the Supreme Court in Roshni T and Abdul Aziz. Lordship knows the judgment. My lord. If it is a civil dispute between the parties, my lord, the remedy is lying with him. But yes, of course, I would come up with the report saying that whether at all any construction has been made or not. This much only, so that he can be relegated to
that is what we wanted.
and that I will come back.
You are coming with Roshni, Supreme Court, such and such.
I coming up with the orders, the genesis of the order from which the appeal has been granted, started.
We will dismiss the appeal.
My lord,
We will dismiss the appeal, but let your instruction come to
I
the-
will come back, my lord. Keep it on the Friday, my
But
lord, I will
Mr.
come back.
Learned advocate appearing for the appellants. Mr. Sengupta, learned advocate.
It's not intentional, my lord.
You also come, what you have done.
My lord, item number 7 and 9, my lord, we appear for the appellant. I'm led by Mr. Mitro. My lord, the state has not been coming for some time, but today they are here. Today, Mr. Chakraborty is here, so yes. Oh.
Yes.
My lord, 7 and 9, my lord, we are appearing. My lord, there's somebody here today for the appellant in item number 8.
Item number 8, my lord.
He appeared for
Yes.
এতদিন আসছিল না।
I have been led by Mr. Aruna Chakraborty. Due to some of personal difficulties, he is not here.
My lord, if my lord permits us to start, একসাথে tagged হয়ে আছে। If my lord permits us to start our appeal, my lord, Mr. Mitro is here.
Yes, who has been engaged? Your senior is there.
Mr. Raghunath Chakraborty, my lord.
Uh-huh.
Mr. Raghunath Chakraborty.
Where is he?
He is not here, my lord. Due to some of his personal difficulty, he is not able to come today.
So you please ask your senior to Mr. Mitro is leading in the other two
Other two
matters. We
matters.
were told that the other matter is similar to that. So
Sometime I am coming on.
তোমার exercise related matter?
next Thursday. Yes, call the next.
Thursday.
I'm led by advocate. Item number 8, I am also not aware. I am not.
Item number 8, my lord, we don't know whether it's actually tagged, somehow it's tagged. Do not
Mr.
understand.
Chakraborty take instruction. If
But I'll
it is
take-
same issue, then when the advocate general is appearing, he can
Well, it has
appear
to
in
be,
all-
but all the issues, I'll take instruction, man, this.
Yes, education.
My lord, day after tomorrow, that
We have kept
Thursday.
it on Thursday,
This
next
Thursday.
Thursday,
Next
Thursday week.
Thursday week. Thursday week.
Item 10, I appear for the private respondents.
My lord,
An application has been filed.
My lord, my lord, in this matter, Mohammad Sarwajan is appearing on behalf of the appellant, my lord. My lord, pay for short password. He engaged in another code, my lord.
Lordship, for the state led by Mr. KJ Yusuf, Lordship. He is on legs, Lordship.
Monday.
Grateful.
Next Monday. এই শোনো, এই গাড়ি শোনো, এই শোনো। এই সাত আট যে অনেক নেক্সট থার্সডে বলেছি তো, যাওয়ার আগে সাহেবের সাথে কথা যে লিস্ট করে রাখবো। সাত-আটটা থার্সডে উইক করেছি, একটু মনে
ফাইলটা পাঠিয়ে দিও তারপর 7 নম্বরে।
ইয়েস নেক্সট ইয়েস
Lordship,
For Monday and Tuesday, I shall be not be in town, my lord, because of a bereavement in my family. My lord, can it be taken up on Friday, this Friday,
তাহলে ওই থার্সডে উইক করে দিও,
my lord?
থার্সডে উইক।
So very grateful, my lord.
ইয়েস
Lordship, I am for the appellant in this matter, Lordship.
ইয়েস
Lordship, I have filed one application, Lordship, for 11, no? For application for curing defect pointed out through report dated 4th April of 25 in connection with the instant appeal. The matter is the CAN application is not tagged in the main application, Lordship.
what is the can number?
CAN 4, Lordship.
It is appearing in the list. It
No.
is appearing in the list.
List. Ache?
কি বল, এটা কেউই না। What is can for? Curing the defect. What defect?
Lordship, defect is the name of the Lordship, name of the respondent number 3, project manager memo of appeal does not find place in the cause title of impinging order, Lordship.
Who is for the writ petitioner?
Read
Respondent?
petitioners. Read petitioners, Lordship, Shri Krishna Kamal Goswami, Lordship.
Have you given this to your other side?
Yes, Lordship. I have served the copy, Lordship.
My lord, I am appearing on behalf of the CFM Facilities Management. My lord, my firm has been given the tender. I am the added respondent, my lord. I had succeeded in the tender. I had participated.
So defect has been removed.
11 to 11, 50. Sorry, my lord. 50.
এই তো defect ছিল।
না আরেকটা হচ্ছে name of the
Have you filed section 5?
Yes, Lordship. It has been
Your
filed,
service
Lordship.
is complete. Have you served?
Yes, Lordship. I have served the other.
এই তো
রিপোর্ট একটা ছিল
এটা
ছিল মাখন সরকারকে
কেটে দিয়েছে দেখছি।
কোনটা
এই
serve
যে
করেছেন
name
একটু
of the respondent number 3,
private respondent।
কি additional point এটা applicable করছে?
Sir,
সেটা হচ্ছে can
I have copy extra.
Project director.
হ্যাঁ project director।
দিয়েছে তো
And দুটো দেখে
পড়ো these are not the-
Lordship, can to is a delay application, Lordship.
You are appearing for whom?
I am appearing for the private respondent slash lead petitioner, my lord.
You have got the section 5 copy.
No,
He has already served, Lordship. And last
Certificate of
occasion is
service you have filed.
I have not received at all. That's it. I have not gotten it. That's why I still want to see that.
Lordship, can you fix it another date, Lordship?
I have not received, my lord. That is why I am asking for see this.
2-3 dates are hearing, Lordship. On the last occasion, hearing the matter, Lordship, of delay, Lordship. It has been served, Lordship.
আমি কপিটা দেখি কে সাইন করেছে সেটা হলে আমি বুঝে যাবো কি রিসিভ করেছে তো দেখি
এইটা তো
Where is he? Who is leading you, madam?
Mohinder Prasad Gupta is appearing this matter. He's engaged in another court, Lordship. Lordship, can you fix it another date, Lordship?
Next Tuesday.
Grateful, Lordship.
বলি টাইম
Order রয়েছে? Order হয় না।
Yes, Lord, I am for the appellant petitioner.
Lordship, Jhuma Chakraborty for state. I pray for accommodation or a short passover. He's on legs.
Next Tuesday. Take it on this- Next Tuesday. What section 5 is there?
No.
Section 5. Have you served upon everybody?
Yes.
Huh? You are for
State. Jhuma Chakraborty is appearing for state, Lordship.
state. Any private respondent is there?
Private respondent appeared.
Private respondent appeared.
Appeared.
It earlier appeared before us.
Yes, Lord.
What happened?
Adjournment was made. Adjournment paid for.
Alright, next Tuesday. Come next Tuesday, Mr. Chakraborty. Yes, ডেকে যাও।
Settlement
Next ডেকে যাও।
13 it's my appeal. My affidavit in reply was sought to be served. My clerk said that he is not available. This is number one. And number two, my lord, I'm in the stage of bereavement. Could it be taken up after some? My brother expired yesterday. After some time.
Thursday week.
Thursday week, মানে 22, 24
Yes, next.
Thursday week. 21, 22, 24
My application,
Alright.
Your Lordship.
মানে instead of
24th.
Thursday week, it can be
24th.
on 25th because 24th it's finishing.
কাউকে বলে adjournment নিয়ে
আচ্ছা, yes. Okay.
Your Lordship, there was a leave to file a supplementary affidavit. We are filing that today. Your Lordship, my other side is here. Your Lordship, and
the
a
copy.
sealed cover, we had before the Honorable Single Bench, we had filed the inquiry report against the misappropriation of fund. We have filed it here as well by way of a sealed cover.
কভারের মেটেরিয়ালটা সার্ভ হয়েছিল না তো?
ওইখানে হয়নি এখানে it's only for Your Lordship. I also don't have a copy of that document. It was not provided even only
You have served supplementary.
Your Lordship, we have.
The affidavit has been served. I mean, my lords, the sealed cover, what are the contents we are unaware of?
That is pertaining to only misappropriation of fund. What had happened that
Completely unaware of what that is.
Supplementary affidavit you wanted to file.
Your Lordship, to show what are the accounts, 5 crores is sent from the central government
No, you take back the report. Keep it with you. When we
when
require, we
required. Your Lordship, I will. শুধু report.
supplementary affidavit, let it be.
Your Lordship. আর একটা নিচেটাও আছে
What was the order about?
Your Lordship, where in this, the respondents had challenged before the single bench pertaining to that central government had brought in the Ministry of Science and Technology.
Is there any scope of
Yes, Your Lordship, there is. For that, Your Lordship had allowed the supplementary affidavit. There are 5 crores which is given by the government to be spent throughout the year, wherein we pay statutory dues.
Supplementary affidavit you have given?
Your Lordship, he has been served.
Technically, well, I had objected since I had been served on WhatsApp.
No, I had given hard copy as well.
Well, I'm being led by Mr. Raghu.
If Your Lordship sees paragraph number 12, there are certain statutory dues which are required to be paid by my officers.
Go through it, come back on Tuesday. Next Tuesday. Supplementary affidavit.
Formally filed করলো। বলছে go through it, come back.
আচ্ছা, লিখে নাও Miss Pandey, learned advocate appearing for the appellants files the supplementary affidavit.
My lord, the supplementary affidavit is a document notarized. Is it not acceptable?
It
to-
is, Your
This
Lordship.
should be,
As
this should be affirmed here, and this should be
If it comes from some other state,
it is coming
can
from
be
Delhi.
punched.
it can be
It
notarized.
has been
Be punched, my lord. Otherwise, it cannot be accepted.
Is it not punched?
punched.
Punched,
Both feast and punched.
then okay.
Even our appelicide rule allows 7 kilometers beyond.
No,
just
that's
for
allowed,
just-
but your lordship, it should be punched. Otherwise, your lordship,
It
that's
has-
okay, then okay.
Much obliged.
Yes. Yes, 15.
Yes, my lord, led by Mr. Galib.
Eh?
Led by Mr. Galib, my lord. I am for the statement.
My lord, in item 15, I am appearing for the added respondent, my lord. I am being led by Mr. Devopom Roy. He is appearing virtual. My lord, CFM facilities.
So what is will you come tomorrow? It is very difficult to hear from us.
No problem.
Tomorrow, ask him to be here present in court.
My lord, I shall.
Topic তো আছে আবার
এটাকে তাহলে
retain his position.
we will keep it. এই আইটেম নাম্বার 15 টাকে ওই অ্যাপ্লিকেশন হেডে রেখে দিও. It will appear under application group 9 fairly at the top. Please ask him to be present in court. It is very difficult. Have you heard us?
Yes, Your Lordship. It's very clear.
Yes.
Very well. I'll appear before Your Lordships tomorrow.
ওটা কি ওইখানটা দিয়ে?
তাহলে সার্ভিস
16, madam, for the respondent, madam.
May I prefer short fast one? Brief is not within only 5
Next
minutes.
Tuesday. Yes, next.
My next date, madam.
Next Tuesday. Yes.
I can see 17, 18, madam. I can see exactly what you're doing. Only the last.
ফোনে কথা বলছি
Sir, what you are doing?
কোর্ট অ্যাডভোকেট
If you behave in this fashion, what will the litigants think?
My lord. Lord, I'm for the respondent, my lord. On the last occasion, my lord, there was direction for exchanging affidavits, my lord. My lord, unfortunately, my lord, we'll be requiring 2 more days, my lord. The server was down and we could not, my lord, access the ledger from our servers, my lord. That's why the difficulty. It has been made available only today, my lord. We'll do it in 2 days, my lord, the affidavit. And I'm led by Mr. Shoptangshu Basan, my lord.
Madam, I am led by Mr. Mitro. Surajit Nath Mitro, as your lordship's last order is that, madam, this in relation to, madam, the auction.
Come on that.
Madam,
We're keeping it on.
let, madam, then,
Next
madam,
Tuesday.
reply to be filed, then the extension to be made.
Oh,
Opposition
opposition.
directions for opposition and reply. They have not yet filed the oppositions. I have to extend the time for giving the reply also. These are the orders.
Very good. Then he is filing within this week. You file your reply. We take it up on Thursday week.
Thursday week.
Yes. File your opposition in the meantime.
I'm sorry, my lord. Should have been. Police नहीं करा. Sorry, my. Yes. Next Tuesday. But the one line order may be given in that event.
Thursday week.
Because they have to file the reply. So Thursday.
No. They haven't yet filed the opposition.
They'll file it by in the course of the week. You file your
We
reply.
will put in an order. It will go down.
Only one line.
Listed. What is the requirement?
It's required, my lord. Only one line. Your lordship is aware of that. My lord,
This required, my lord, only one.
কবে রাখলো রে?
তাকে নিয়ে ভাবে বসে বসে ফোনে কথা বলে।
ডাকবে না?
Lordship, item 19, Your Lordship, I appear for the appellant.
2 o'clock. 19. We are 17 and 18.
17, 18 both taken up.
Come back.
Yes.
Not before my learned senior friend starts, my lord, but I prepared. Hi, yeah. Lord, kindly, my lord, recollect the matter regarding the promotion on consideration from class 8 to class 9.
Yes.
Now, my lord, during pendency of the appeal, my client able to collect the mark sheet of the private respondent and the transfer certificate of the private respondent who promoted from class 7 to class 8 on consideration, class 8 to class 9 on consideration, and thereafter in class 10, she failed.
Mr. Shandal's client?
Yes. But I already prepared a supplementary. If anybody will also kindly grant me leave, I can use it.
Supplementary affidavit, how can it be, man?
I can.
No, at no point of time this was a question.
Because last occasion, your lordship was pleased to observe, and my learned senior friend was also pleased to submit before your lordship that yes, we are ready to produce our mark sheet in class 7, 8, 9 that we have passed.
Well, that's I submitted, but that's not the point.
But
you have never questioned
the
that.
Lady who could not pass class 10, the final examination.
No, in the writ petition, did you crave leave to refer to any document?
No
It was
point of time.
subsequently. But I should be candid before your lordship. I should be candid before your lordship.
Supplementary affidavit.
But if your lordship kindly allow me, I can file it, and my learned senior friend can take instruction to that.
No, my lord, I am opposing supplementary affidavit. This is not the procedure. And no point of time he raised this question.
But a person who is claiming
We will hear to you the objection. Otherwise, he has to, at this stage, if it is a document which is pertaining to the case, certainly we can look into it.
Well, certainly, but there is a procedure. Then I can take exception to that. My lord, point, my lord, I tell your lordships. I'm frank. This was not an issue.
I am saying that if that is taken on record, we give you an opportunity to deal with this.
But not your lordship, my lord, it is settled. When my lord, it is settled when supplementary affidavit can be filed and when cannot be filed. This is not the procedure in appeal. At best, order 41, rule 27. At best, order 41, rule 27, not otherwise.
You are being technical, Mr.
Malad, then civil procedure is technically.
Read court, what's
even read court. Even read court. Even read court. And my first objection, at no point of time this point was raised. No point of time. There are 3 writ petitions, if I am not wrong, moved, not at any point of time.
That was your mark sheet. They could not.
They could have not questioned it at all.
How could they get it?
They get it, how they have got it now. The same way they could have got it. The same manner they could have got it. When this was not issue, my lord.
Then if he opposes, then in that sense, you have to come with an appropriate application.
Then I have to come with an application.
To that he has
because the first writ petition filed by my learned senior friend clients on the ground that I am.
No, whatever it is, Mr. Shandal says that it is a question of addition to the pleadings. Na? You are relying upon some documents.
Yes, but I should have. I said then I shall have to come with the application.
In spite of due
but my learned senior friends clients also required to show that she is eligible.
No, my lord, I am not required right
She is eligible.
I am not required.
To that Mr. Shandal will use his opposition.
Copy then.
I am not.
Yes. Passed on consideration. She obtained 210 out of 800 and she have been passed with consideration in class 8 to class 9. Before that, class 7 to class 8 on consideration.
Then how can we hear today? We fixed it today for hearing.
My learned friend has not come up with the application either.
But this is a fact, my learned senior friend, my college not easily.
Oh, my lord,
I'm
I'm at the basic point. Was it a question before any of the court below? This was not an issue. My lord, we are concerned with the judgment.
Mr. Sandal, we cannot call for some documents.
My lord, I tell you,
As
lordship,
court, we can
with respect to your lawsuits, if this is not related to an issue, your lawsuit should not. My eligibility was not at issue. Kindly consider this. My eligibility was not at issue at any point of time. When he
So we keep it next Thursday, you take appropriate steps,
My-
otherwise we continue with the
My lord. But much obliged.
next Thursday রেখে দিও list.
Thursday week.
অ্যাপ্লিকেশন যদি ফাইল করে তাহলে অ্যাপ্লিকেশনটাকে হেডে চলে আসবে। আমাদের অরিজিনাল একটা কোটা আছে না স্বাধীন। Yes. You are for item number 19. Mr. Dey, you are there.
I'm for the state. Mr. Siddhartha Banerjee was for the petition.
Lordship, I am paying unconditional apology for that reason.
See, what happens is there are litigants, there are juniors in the profession, they will see you and they'll get a
Lordship,
wrong
paying
impression.
unconditional apology.
That is the only difficulty. Maintain some discipline in court.
Lordship, I am for the respondent number 8. For the respondent number 8. Lordship, praying for Passover, something senior will come just within few minutes.
Today, yes, দেখে যাও 20. Mr. Dey, come tomorrow. Not today.
For not today. Mr. Shoptangshu Basu is appearing for the appellant, Lordship.
Yes, next.
Lordship, Passover, I'm praying for Passover. He is coming, Lordship.
Yes, next.
My lord, I am for the appellant.
Lordship, item 27, I am for the respondent writ petitioner. My lord, I am praying for not today only. Mr. Rahman is appearing in this matter. Paper book is he is seriously ill, only for not today.
What is the matter about, Mr.
The matter about present petitioner, my lord, in the writ petition, respondent number 8 is a sub-inspector attached to CID. At that time, when he investigated one matter at Murshidabad, my lord, upon the complaint received by the victim on 376 case was started. But that case was acquittal. Thereafter, my lord, accused person filed a writ before this honorable court, my lord, directing, praying for direction for disciplinary proceeding against me. That was allowed by the honorable single judge. Against that order, I filed a intra-court appeal. Honorable division bench comprising Honorable Chief Justice, my lord, state the order.
The paper book is ready.
Paper book is ready. My lord, last occasion, your lordship already.
Yes, I have received the instruction that matter is running in the list. Only my lord give not today. Tomorrow we will.
No, let us start. Let us understand. What is the matter? You are not ready.
I am ready.
You place.
মনে রেখে তো order করে দিন।
That's the evidence service studies আছে না?
সুপ্রিম কোর্ট থেকে অ্যাডভান্স আপনার সামনে ফোন নাম্বারটা দিচ্ছি আমি। একটুখানি
इसको तो both sides ready to the matter.
Who is for the state?
I'm for the state. সরি গলা বুঝে গিয়েছে আমি তোমার জন্য হাসিনি সরি অসুস্থ হাসছে সরি
Yes, any problem?
কিন্তু তোমার উপর দিয়ে বেরিয়ে গেল मतलब पेज 59
Yes.
One is having a sore problem, one is having a
मतलब then my lord मतलब inless gown my lord the lordship kindly advocate
this week.
inless my lord
ten. 10 we called in the morning. Oh, respondent number 10.
Sorry, ma'am, for the state special officer.
Oh, you are for the state.
They will be,
Omol Sen appeared this matter
Sir, it has special appointment.
Take your perimeter.
well, only not today my lord
No, no, we made it not this week. Next. Next.
30, I am for the applicant. 29, to publish a report before the lordship.
28 you are for CBI.
No, my lord, for NIA. Lordship, you are pleased to file a report, my lord. Your lordship.
Come on that day, your appellant is not here. Which is your item?
30.
30 call হয়েছে নাকি? Yes, who is your other side?
The side is not here.
What is the matter? Tell us.
Last occasion, my lord had the occasion to deal with the matter where a deed has been the product of forgery, registry office, it is found. My lord wanted to know what is the quantum of land out of which the deed was executed, asked me to verify it, and I have got the document. Issue was that a document intended to be registered 88, it has become 99. Then, my lord, that matter.
Who is opposing you?
Mr. Siddiqui is for Mr. Siddiqui. Tomorrow, my lord.
Next week is combined list down.
But my lord, it will be tomorrow.
Next week. Inform your others. লিস্টটা একটু খুলে দাও
Telling matter and item 23.
95.
Lordship, I am for the appellant in this matter.
Item 19.
Item 19.
You are for the appellant.
Yeah, yes, Lordship.
Yes, who is leading you?
Lordship, Mr. Banerjee is in this matter. He will appear in in another court. He will appear in VC.
Sorry, ask him to come. Not today.
Item number 20.
This
22,
23 বলেছিল না?
23, 24, 25, 26 and 27, 28,
কি assignment বলেছিল?
29,
এইটা কি?
30,
এই কার্তিক, এটা কি মামলা গো? আইটেম নাম্বার 33 টা প্রাইমারি ম্যাটার। ও এটা লিস্ট আছে।
31, 32,
জিজ্ঞেস করো both sides appear আছে। Any matter where both sides are here?
Lord, we are there in item number 29 of your lordship supplementary list. But Lord, there are other parties also. But this was with respect to that Ukil Bhedi matter. Well, I wanted to be added as a party in the writ petition. There, Mr. Ghosh's writ petition, I wanted to be a party. He wanted implementation of a report. Lordship's pleasure, my lord, to fix
Then
a
let it be
date,
not
my lord.
this week.
Lordship's pleasure, my lord, to fix a date, my lord. Why? We have called the
We
matter.
have called the matter. You people are not ready.
But other
We are
parties-
calling from the morning. Either this side
Yes,
present,
Lord.
that side absent.
That's not call the entire combined list, and then
Since
people
we
come
do-
and mention and say you're not taking up matters.
This has become the practice since we do not dismiss it for default. That is why this is the practice. Both way it cuts. If you dismiss for default, you enhance the litigation. You do not understand. I could have dismissed 30 matters. We could have dismissed 30 matters. Our disposal today would have been 30.
List would have come to an end. But again, recalling and everything.
Take it off.
29. ওটাতেও তো অ্যাপেলেন্ট নেই। ওটাতে কি অ্যাপেলেন্ট আছে? না, আমাদের তো সবাই নেই।
Original side টা কোটার দিকে আছে?
জিজ্ঞেস করলাম দাঁড়িয়ে সবাই তো নেই, সশস্ত্র না থাকলে
আচ্ছা, dismiss করতে হবে ওটা ছিল সব।
হ্যাঁ, উঠে যাচ্ছে যশা একটু থাক তোর গায়ে রাখ পরে সব তো হয়ে গেল।
তোমার লোক কোথায়?
হয়ে যাবে টাকা লাগাবে
Lordship, I'm mentioning under a compelling situation, Lordship. There is an appeal specially assigned to you and your Lordship and Justice Parthasarathi Chatterjee in 2024. I have mentioned earlier also, but the problem is, Lordship, now in the suit, the plaintiff has filed an application for summary judgment, and they are relying upon the impugned order under challenge in the final argument, Lordship. So, Lordship, my
This is the first time you are mentioning, sir. I sat with Justice Chatterjee. You were not there.
Sir, I Lordship mentioned on two occasions.
When?
6 to 7.
Are you mentioning upon notice?
Lordship, I'm mentioning upon notice. I'm mentioning upon notice, Lordship.
Is the original side?
Original side matter, Lordship. Specially assigned to you and Justice Chatterjee.
দিয়ে দিও একদিন যেদিন বসবো।
I filed.
ও তুই জাস্টিস চ্যাটার্জির সঙ্গে যেদিনকে বেঞ্চ থাকবে ওই কত তারিখ আছে ওই ডেটে একটা ইয়েতে keep watch when I sit with Justice Chatterjee, it will be there in the order.
I'm under a compelling situation, otherwise judgment will be passed, Lordship, and I will have no recourse. My entire appeal will be infractuous.
Let us sit together. The next date on which we sit together, it will be there.
Grateful.
Great.
July. Great.
But as appealing for the appellant, this one, my appeal.
Mentioning.
What is that? What is? Discussion.
So we have dealt with all the points that you have urged and the respondents have raised. We have set aside the impugned order and allowed the appeal. However, you will be paying costs of rupees 30,000 because of the delay. 10,000 each to the three respondents, 1, 7 and 8, within 10 days. And you shall, on the next date of hearing before the learned single judge, you shall go ready with the affidavits, the supplementary affidavits.
এটা সাহেবের চেম্বারে পাঠিয়ে সব
সুপার হয় নাকি ফিক্স ম্যাটার
Lordship seeking short passover because senior advocate Prosenjit Mukherjee is engaged in another court.
Let him start. Ask him to come.
Well, this is I'm frankly speaking to your lordship, this is an appeal against an interim order. But my lord, my basic point is that I'll be urging 2 points. Basic point is entertainability or your lordship's maintainability of the writ petition. That's why I'm before your lordships. My lord,
Provisional assessment. Yes, Mr.
well, kindly first peruse the order. That's at page 55 of the stay application.
Page 55.
5. If I'm not wrong, my lord, that's page 55. And my endorsement is like that.
Yes.
I'm not reading it out, Your Lordship. Kindly go through it.
Yes.
Now I tell your lordships, this order of final order of assembly, your lordships, the learned single judge has noted 2 points from the order of final order of assembly. This is a case of alleged case of theft of electricity. In case of theft of electricity, it's primarily governed by section 135. I will place before lordships of the Electricity Act 2003. And assessment is also made under for unauthorized use of electricity, which includes theft of electricity under the section 126. I will place both the sections. Now, this order was passed on 7th June 2023. That's at page 50. At the top, this was written 5th June. I will explain it that. But I'm on the point, your lordships. 7th June, admittedly, he received it. I will take your lordships to the writ petition.
Received what, Mr.?
The final order of assessment. But often, your lordship, somebody comes and allege before the court that he was not served with the order of assessment. Often, matter. But this is not a case. He admittedly received on 5th June 2023, 15th June, paragraph 11 of the writ petition, running page 25.
Yes.
Now, this order of final order of assessment is preceded by a provisional order of assessment under the Act. Your lordships will be getting it at page 45. Here, my lord, the provisional order of assessment, my lord, spell out what is the unauthorized use of electricity, the nature of unauthorized use of electricity, and according to the mandate of the statute, it is also written when the final hearing will be given to him, if he has any objection. That your lordships will be getting at the last paragraph at page 45. He will be giving hearing by me on 7th June 2023 at 11 a.m. Now, this or next page, your lordships, whatever the photograph was taken during inspection, that was served upon him, and with the your lordships inspection report, that's vital, your lordship, page 48. Everything was given to him after with the provisional order of assessment, so that he or she can come up and make out his case. That's the requirement of the law. But kindly see, this is, my lord, this is domestic connection, unauthorized distribution of electricity. What he was doing, my lord, see what he was doing. He was bypassing the metering connection. He was supplying from his cutout to all of the areas, nearby areas. Now, kindly see the finding. Direct connection found from CESC's incoming service cable, core, CORE, bypassing the metering arrangement. During inspection, tongue load was found. There is no was, I'm sorry, found 27.3 ampere. But while taking a photograph, it drops to 5 ampere. Planet judge has also taken a note of this. Then why could you take 27? But he is bypassing the meter he was supplying electricity. This is sometimes called raid. Without notice, just go there and affix a notice, and then otherwise, I can't. If I give a notice to the thief, he will not steal the electricity in front of mine. That's also version of the Honorable Supreme Court. The no notice is required. But even then, before entering into the house, we paste a notice and give a notice. Now, when we taking the photograph, it came down to because of the he took out the wire because he was cut from the cutout, and that's why it dropped. So we have given both, informing this was the situation. This is supported by your lordships. Suppose your lordships against me, you can't go 6. I will substantiate before your lordships 27. That's on merit. I'm just showing to you. I will take my entertainability point. The core choir use 4 mm. 4 mm, 4 size of choir was seized for the criminal case. Caesar list is there. I will show to your lawsuits.
Complaint lodged. Complaint lodged.
Yes, criminal case is going on. Now, this 4 mm choir can be only used to 27 ampere or more, not for 6.
Where do we find that?
That's your lordships will find during this Caesar list. Caesar list, your lordship, I have the proceedings up to date court record. I will show to your lordship the Caesar list also. 4 mm.
The assessment which has assessment we assessment take without the price is important. করতে গেলে 50%. 27 till this information as a maintenance. So, assessment suspicious Yes, Mr. Sir.
Now, page 48 again, your lordship, after the column finding, or your lordship, it's finding because special notes were scored out. Well, kindly consider this. The unauthorized supply of electricity was being distributed to the surrounding area and the occupiers of the aforesaid premises. This was, now your lordships will find the total calculation sheet was given to him at page 49. Your lordship, one point I will just show from you, lordship, because that has been taken note of. Load factor 0.50. Has your lordship got that? From the left hand side, third column.
Yes.
Load factor 0.50. Malad, this is statutorily set in the regulation. What would be the load? Malad, this calculation totally based on statutory calculation. Now, next page, Malad, the final order of assessment.
Now, you calculated it on the basis of 27.3 ampere. That is what the judge says.
Exactly, your lordships.
Not on 5 MP.
Not 5 MP. To 27.3 ampere amounts to 6 kilowatt.
6 kilowatts. Yes.
Now, this is the statutory calculation. Now, your lordships, kindly page 50. This is the final order of assessment.
Yes.
Your lordships, kindly see top up and top at the top of it, right hand side, 5th June 2023.
Hmm.
Then your lordships, kindly come at the bottom. The consumer was intimated through the order of provisional assessment dated 24th May 2023 to appear for a hearing before the assessing officer on 7th June at 11 a.m. and was also requested to file written objection, if any, within the stipulated period mentioned therein. Then your losses, kindly see the next page. Madina Bibi, present beneficiary of the subject supply, appeared before me on 7th June 2023 and made the following verbal submissions. Admitted the unauthorized use of electricity at the said premises, but for a shorter period of time. Prayed for favorable consideration of the penal charges. Malad, he prayed for shorter period of time. I tell you, lordships, statutory presumption is 12 months. If we cannot, Malad, specify any longer period of time, statutory period of 12 months, whenever unauthorized use of electricity, we can't go beyond that unless we can show before your lordships that this is a longer period, admittedly for these reasons.
The statutory period is
12 months.
Yes.
Now, Malad, this is the situation. Then final order of assessment. He prayed for, Malad, I think, Malad, provisional order of assessment was something more than that. After consideration, this provisional order of assessment at page 49, 5,15,000. And your lordships will be finding, your lordships, the final order of assessment, 4,38,000.
Yes. But Mr. Sannal, the issue has not been decided at the end.
Exactly. Malad, this is 7th June order.
7th June. Yes.
Malad, appeal has to be filed within a month. Now, Malad, I will take your losses 2-3 paragraph from the writ petition. He is first saying that this was written.
No, Mr. Sannal, the court appears to have come to a prima facie finding that there are certain infirmities in the assessment which was made. As such, I will hear the matter. But for as under 3135 1A, it is the assessed amount which has to be put in. Court has said that not the entire 1,75,000, we will hear it.
The court should not do that. That's my point. Kindly don't take me amiss. I'm saying it what? I will show to your losses 2-3 judgment on that. Malad, appealable period 1 month.
He has come beyond that period.
No explanation. First,
the entire amount will be subject to the writ petition.
It's the entertaining of the writ petition. Can it be reopened now?
Mr. Sannal, entertainability is 127.2. You have 2 points.
No, on why
entertainability on 127.2, you spend the time and then you come to writ court. This is not maintainable since he has not taken the alternative remedy provided under 126. This is your one argument.
Another is also contrary to law.
Another argument is you cannot direct me to receive something which is lesser than the assessed.
I tell you, lordships, when this is a case of theft of electricity, Act says restoration can be done only upon full payment.
Yes, 135 1A.
Then if it is a statutory mandate, why should it be given the half of the amount?
Statutory mandate is that does not mean writ court is taken away of its discretionary power.
I tell you, losses here, my lord, this is a case of theft of electricity. According
Yes,
to
you have
Supreme Court,
initiated a proceeding.
but that's my lord, criminal court.
Today the only issue is, suppose the assessment, good, bad, indifferent, is found to be doubtful in the mind of the learned single judge.
That's
when the basis of 135 and 1.
I get your losses.
So that
Even
court
for
has
that,
said,
my lord, even for that, our High Court division bench says one has to come within certain time. One has to come.
you will reject the writ petition. It has been made returnable. You
No,
will
my lord,
be
I tell you,
once you if the writ petition is thrown away, everything goes back.
No, my lord. Then your losses. I'm on the point because I'm on the threat of suo motu contempt. Now, unless you have not restored, I'm against that. I am against that. Your losses, I tell your losses, the law.
No, you comply for a
That's your
particular
losses.
period.
That's my point.
Matter will be hard.
Court should not have passed that order. That's my point. Malad, alternative remedy is not a bar in 3 cases.
Mr. Sannal, you are being a bit harsh.
That's malad, not bit harsh, your lordship. We have. Malad, in the theft of electricity, we have to. It's a menace to the society. Malad, just technical one typographical fight. I will take your lordship to the writ petition.
Your assessing officer is not an appellant before us. It is filed by CSC Limited. Your assessing officer who has passed the order, he is not a appellant before us. He is a pro forma respondent in the appeal.
He's not your lordship because he is an officer
126
of CSC Limited.
126 basis is judgment of the assessing officer.
That's an officer of CSC Limited.
Why you haven't you included him as a appellant on your side?
No, that's Malad probably. I tell lordship why.
No, we had just pointed.
I tell you why. This is done, your lordship, for one reason, because he has to come, file local Aknama, all these. These are licenses be. That's your lordship. If I take your lordship, all the officers has to sign in the local Aknama. Then appellant statutory bodies will not be able to file an appeal immediately.
All right, Mr. Sharma.
Now, yeah, I take your losses to that. Now, Malad, my first question, whatever point has been argued before the learned single judge and taken note of the learned single judge, Malad, that point was never urged by the petitioner at any point of time for more than 1.5 years.
How your appeal is maintainable, Mr. Sannal? It has not decided anything finally.
Interim order, Malad.
Interim order has not settled the rights of the
Malad, I am on
parties.
the maintainability point.
Maintainability 127.2. That is your
Not
argument.
122, my lord. Alternative remedy, I am conscious alternative remedy is not a bar.
Right.
But when? Malad, when?
That is you're saying that had you come before the expiry of the period of preference of the appeal, then I could have understood.
Exactly your losses. That's your losses I will be showing to your losses.
Your assessing officer passes an order on 7th and dates the order.
Malad, even I tell your losses that. Malad, suppose your losses he has repeated on 15 June 2023, he could have pointed it out. Why not your losses? He could have pointed out.
You have not explained why you were.
I'm taking your losses. That I'm placing the writ petition. Your losses kindly first, Malad. 3 paragraphs I will be showing your losses. 9, 10, and 16. Malad, 9, 10, and 16. Well, kindly come to your losses.
Paragraph 9.
Paragraph 9. The petitioner states that on the basis of the false report submitted by the respondent number 2.
Who respondent number 2 was the
Well, I take your losses.
respondent number?
CST Limited.
No.
These are designated officer.
He's above the assessing officer.
Malad, designated officer, he has written there is no such officer, your losses, assessing officer.
That is respondent number 3.
Different.
Who went to make the assessment, not the assessment officer.
Assessing officer, Malad, personally inspected. That's now our judgment. The assessing officer has
to.
Then Asimon thereafter your losses also. Malad has to make it. Malad,
but here it was the assessing officer. All right.
The same officer passed the final order of assessment. Now your losses kindly consider paragraph 7. 7, 9, 10, 16. This is the all case make out my losses. The petitioner strongly denies any unauthorized illegal use of electricity. Petitioner demonstrates there is no question of unauthorized. Now, Malad, kindly prevaricate it with the final order of assessment submission recorded. Would your losses in a writ court go into this? What is inviting my learned friend's client to do to be done by the writ court? Then your losses kindly come to losses. Then 8.
Decision making process. Wait. Sumoto content. সেই জন্য যাও
I'm not at all, my lord, if the mentability point is decided by the learned single judge. I'm not. But your loss is kindly because disconnection more than 2 years now. There is no hurry for restoration. A person comes up after 1 year, 6, 8 months, 1 year for against the appealable order without filing an appeal. No explanation why he didn't file appeal. So I will frame a different issue, your lordship, before. Kindly see page 9, paragraph 9. The petitioner states on the basis of false report submitted by the respondent number 2. The respondent number 3 has raised the instant provisional assessment dated such and such on the same date, most probably within few hours from the inspection, without giving any opportunity to the petitioner for placing his words. But against provisional order of assessment, no hearing is required. It was not explained and clarified either in the provisional order of assessment.
Mr. Sannal, the first line, his allegation is on the basis of a report submitted by respondent number 2, respondent number 3 raised the provision.
My lord, the report I have placed before your losses, kindly have a look at page 48.
This is unsigned. This is
the report, my lord, prepared.
Prepared by whom, Mr. Sannal?
My lord, that's your losses, my lord, the team assessing officer. He must be present over there. There is a team goes, your lordships. Team goes.
Why does he say a report submitted by this one?
My lord, that's his, my lord. Because I have supplied to everything to him.
Yes. Yes.
Then, your lordship, it was not explained and clarified either in the provisional assessment or in the calculation sheet as to how the assessing officer arrived at the amount. Provisionally, what are demand factor, load factor, what basis figures of 50 was taken as demand factor. I will right now say this is statutory. Well, these points, if at all, these are all appealable points. This is not point for the read court to go into. These are all factual bases. Then your losses kindly see load factor or how the number of days taken as 365 days with 24 hours each days.
Yes.
Then petitioner was not allowed an opportunity to make submissions by before the assessment. This is provisional assessment. Then your losses kindly see your assessment 7th June appeared through his own abament. Your petitioner on 7th June 20 appeared through his authorized representative and wife before the respondent number 3 for hearing and denied the allegation verbally. So he didn't make any written submission admittedly. He was given an opportunity of hearing. He didn't. Now 1 year, 12 months, my lord. After that, he comes up before the court. Then your losses kindly see 11. On 15 June 2023, the petitioner received final order assessment letter. But here I make a submission, your lordships. Suppose after receiving this, because the next abament I will show, he finds that 5th June order was prepared according to him before giving hearing to him. That's his case. In the writ I will show. No, my lord, any normal ordinary man would immediately write a letter. This order was prepared, even to the assessing officer. Even if he is functus officio, so that he could make a point and come up before the court. Then look, this was done by you. So you didn't do it. So this is afterthought. You find that typographical mistake, come up one fine. Well, I tell you losses sometimes. Some of the honorable judges very harsh, some of the honorable judges flexible. Somebody keeps that matter pending. When an honorable judge who is more flexible, I will move it, and I move it. It's not known. Well, this is, I'm not saying anything wrong. So if one wants to do that, keep it pending, then what will happen, your losses?
How many matters you have done?
That's your losses. That's your losses. Here, your losses, the point comes. Now, here your losses, I will show.
Senior man is behind you, Mr. Soptangshu. Yes.
Now your losses kindly see. Paragraph 11. On or about 15 June 2023, the petitioner received final order of assessment letter issued such and such and was surprised to see that the assessment already prepared on 5th June. So, my lord, he came to know on 15th June.
Why didn't he write a letter?
Exactly, your lordship. Mal, some contemporaneous document had it been there, my lord, I could not have come up before your lordships. That look, this is something otherwise. Your lordships will not find anything. Then your lordships will find 13. The petitioner states more than 1.5 years past, the petitioner continuously in touch with the authorities. Pleading consideration, the same was denied. The authorized authorities remain silent. Is there, my lord, any probative value of this averment? Then your losses. The only consideration made so far by the respondent authorities, payment of finally assessed amount in installment, and as such the petitioner was supplied with a format. Now your losses go to the format, this annexure P4, I just showed to your losses. Page, that format P4. He has annexed it. Who gave him? When it was given to him? No pleading, your losses. Maintainability point, I'm conscious of the fact that has to be assessed on the basis of the averments. It's a point of demurrer. It's just like order 7 rule 11. On the basis of plaint, whether replaint should be accepted or not. This is the standard of averments. Who gave it to him? Now, even if your lordship, it was given to him, you went there, you paid for installment, that's why given to you. What's wrong? That doesn't mean that you will not question that order. Then your losses will find, after paragraph 13, your losses will not find, I do not find any, my lord, averments which needs, my lord, this, my lord, explanation. Your losses, normally explanation is given at page, your lordships, at the bottom of the petition, my lord, after the grounds, normally. I do not find anything, your lordships. Any sort of explanation comes up.
Yes, Mr. Mukherjee.
My lord, I will just cite 2-3 judgments on that. No, my lord, this is a point, my lord, we are taking. This is not, once this is started allowing, we will be in a soup, my lord. I could have understood I have made a mistake. Appealable forum, you apply it. Now, even if your losses, sometimes this point, I am frank to your losses. Huge amount, 50%, how could I pay? Now, that point have also in Calcutta Corporation matter has been decided up to the Supreme Court. That cannot be a ground. Now, your losses, 50% is, my lord, that's statutory matter. This is also not his point. No explanation. Now, your losses will find grounds. He has taken out 2 points, your lordships, on the ground. Demand factor was taken 5-0 at paragraph 5. Page 30. Page 30. Connection. কত পেজ অ্যানেক্স করেছো তো হ্যাঁ রেগুলেশন অ্যানেক্স করেছো my lord, he questions first, my lord, fifth. I tell you lordship, this is typography on the ground, we have said it. Yes. Because he appeared on 7. He didn't question at any point of time. Therefore, by way of read petition, he cannot question it after almost after 2 years. Second point, my lord, demand factor. Your lordship, kindly come to regulation page 75. This statutorily, how it is to be done. Even the assessing officer has no hands.
Cannot be done. You will win in the writ petition. If the writ petition is decided, Mr. Sannal, all
that's my point. It cannot be decided.
Now, Mr. Sannal, you cannot say that the writ court will not exercise discretion.
When it can be done, I will show to your lordships.
Yes.
That's my point. When can it be done? I'm sure that your lordships is annoyed with me. But, but this is the point, my lord. Because I have faced it, I will show to your lordships. Now, your lordships, page 76, load factor, what would be the statutory? 50%.
Today we are on the point of stay or not stay.
Now I check your
stay or not stay.
My lord, Sudipto Kole first. My lord, this is reported হয়েছে বোধহয় But I'm showing, my lord, this question arose before the division bench. না তোমার আর একটা কপি আছে দাও না আমার কাছে Well, several questions arose whether appellate authority can condone the delay, all that. After the Supreme Court judgment, Malad, division bench also said initially against me, but ultimately held that no, division bench cannot condone the delay. Malad, I will be on the very last point. Here I tell you, losses. Before your losses go through one, I must mention there is a Kolaboti ki jano judgment now. Kolaboti. Well, there's judgment by the division bench presided over by the Honorable Justice Bhaskar Bhattacharya.
Kalabati Doshi.
Kalabati Joshi. Now, I argued your losses here. Division bench hold, Malad, barred remedy cannot be entertained by the read court. Malad, against this, Malad, I am frank, your losses. This division bench, more particular Justice Dotto, was against me. Now, suppose a person could not file appeal within 30 days. He comes up immediately thereafter and shows there is a violation of natural justice. Can the writ court entertain this point? Well, ultimately, court says if there is an explanation, then only court can. Otherwise, not, because you have not availed of statutory remedy. But court didn't subscribe the same views of the coordinate bench. Barred remedy. Barred remedy means he cannot come up at any. I am also there. It's not, it should not, because law to some extent hurts. But that's the statutory wisdom of the legislature. Now I take your lordships to the last point. Paragraph 42. I will not read the entirety. Before parting, we wish to deal with the observation in Kolabonti Doshi Trust that a read court should not, by invoking under Article 226 of the Constitution, revive a barred remedy is the settled law. The observation, in our view, narrows the amplitude of Article 226 of the Constitution of India. Mr. Sandal was called upon to address on under what circumstances law had been previously settled. The read jurisdiction cannot be exercised to revive a barred remedy. We received no answer. Then your losses. 43. We need to clarify the position. Take the case of a consumer who, despite the remedy of an appeal under Section 127 being available, invokes the read jurisdiction by challenging an order of assessment passed under Section 126 of 2003 Act within 20 days of such order, and prima facie satisfied the court that any of the conditions for entertaining a read petition, despite such existence of alternative remedy is present, whereupon the same is admitted and the interim relief is granted. However, at the stage of final hearing, say after 6 months, the learned judge is persuaded by the company not to hear the read petition on the merits or in view of availability of the alternative appellate remedy, which leads to dismissal of the same on this ground only. By such time, the limitation to approach the appellate authority under Section 127 as set in, and by reason of non-obstruction of principles underlying Section 5 of the 963 Act, the remedy of appeal has become barred. In such a situation, can the read court grant leave to the consumer to avail the appellate remedy and direct the appellate authority to hear the appeal on merits? The answer to our minds should be in the affirmative, or else for entertainment of the read petition by the court and for its subsequent dismissal later on the above ground, the consumer would be non-suit. Well, this is not the situation here. He comes up after 1 year, 6 or 8 months, or almost 2 years. Now kindly see the next paragraph. We are conscious that the delay in preferring appeal under Section 127 within 30 days could result in the person against whom an adverse order under Section 126 has been passed being left with the statutory appellate remedy without the statutory appellate remedy. However, we are also of the opinion that such a person would not find himself totally without any remedy. A final order of assessment under Section 126 could be a subject of judicial review if any of the conditions of entertainment of a writ petition, existence of an efficacious alternative remedy notwithstanding, is satisfied. If indeed the writ petitioner satisfied the writ court for genuine reasons, he could not avail the remedy of appeal. Genuine reasons, your losses. Could not avail the remedy of appeal and seeks a writ of certiorari. to have the impugned order quashed, the Reed Court may, in its discretion, enter this petition and judicially review the decision-making process, drawing inspiration from the Constitution bench of the Supreme Court reported in AR 1966, 1506. Then, Your Lordships, however, if the Reed Court is approached long after the final order of assessment, exactly the same situation, understay is made, and proper explanation for belated approach is either not shown, or the court is satisfied that the appellant disabled himself to pursue the appellate remedy for his own fault, the Reed Court may not entertain. Now, my lord, kindly consider the statements now. No explanation, any reason. My lord, defect shown in the order, even if your lordship accept them, cannot be a ground for entertainment of the petition. Am I clear to your lordships? You are showing defect in the impugned order, illegalities in the impugned order. This is not violation of natural justice. Illegalities for so many reasons. That cannot be a ground for entertainment of the petition almost after 2 years. After you exhausted the appellate remedy deliberately. That's your losses. Well, the 2 paragraphs, your losses. Yes. Kindly, your losses. I'm reading it once again. But after, my lord, first 3 lines. A final order of assessment under section 126 could be এখানে কোন প্যারাগ্রাফ গুলো আমার ডায়েরিটা আছে এখানে কোন প্যারাগ্রাফ গুলো দেখাবো বলে গেছে ওই অর্ডারটা আরে এর মধ্যে রাখা ছিল মানুষ আমি বার করে টেবিলে রেখে থাকলে external cases sufficient explanation is important বললে তো সব রাস্তা বন্ধ শেষ
Mr. Sannal, when was the pro forma given to him?
Well, this is his case. Who gave him to him? Is there any abamment? Kindly have a look at the paragraph, your lordships. Even the pro forma. Pro forma for my lord, installment, paying for installment, according to him. Page 11, your lordships, if I'm not wrong. No, page 30.
Para 30.
Para 30. Who gave him? When gave him? Well, this is available even in your lordships at the doorstep of the CSC's office. Printed copy.
Yes, tell us what.
My lord, I'm relying upon another judgment of the Supreme on the same principle, your lordships. That's your lordship.
That is, your argument is without, there is no explanation towards the delay. After everything was closed, he has approached, which is debarred by the order of.
May your lordship allow me to frame issue, the subject to your lordships. A person having deliberately not availed the statutory remedy of appeal. Having deliberately not availed of, because your lordship, no availment why he didn't avail of the remedy of appeal. Having deliberately not availed of the remedy of appeal, can question the, my lord, assessment order almost after 2 years without any explanation whatsoever for approaching. Even if your lordship, the normal rule of approaching the Reed Court, it should be, my lord, there is no limitation. But one would come up and approach the Reed Court, your lordship, as the first available opportunity. He received the order.
At a belated stage, the Reed Court would have granted him leave that, all right, you file condonation and go for the appellate.
That's your lordship, Supreme Court says no.
That is what the Supreme Court says. That is this judgment which you are referring. That was answered in the positive. This last paragraph, kindly see.
Malad, the Justice
Datta's-
Division Bench.
Yes.
Yes, I'm on. Malad,
The-
which paragraph? 44.
By such time, the limitation to approach 43. Appellate authority under 127 has set in, and by reason of non-attraction of the principles underlying section 5 of limitation, remedy has become barred. In such a situation, can the writ court grant leave to the consumer to should be in the affirmative?
Exactly. But what facts, Malad? In that case, Malad, it's a Malad hypothetical case. It happened in lawsuits exactly in Kolaboti. What happened, your lawsuits? Assessment order, final assessment within 30 days before the writ court. When your lawsuits, the point of maintainability was not taken. Now, at the final hearing, point of maintainability was taken. And on that ground, writ petition was dismissed. That's why court says he approached the writ court within 30 days. Therefore, I can have a leave. Kindly have a look at this, your lawsuit, paragraph 1.
This argument, Mr. Sannal, should be before the writ court itself. Throw
Then, your
away the
lawsuit,
writ petition.
I can, Malad.
You are not proceeding. You are saying that assessed amount not paid, so I cannot give this. It is subject to the writ petition consideration. This is an argument which you are making, which you ought to have made in the final hearing.
That's why, Malad, before passing interim order, the learned single judge ought to have heard this point. That's my point, your lawsuit. Having passed an interim order means the court has been entertained.
Issue has not been finally decided, Mr.
Malad,
Sannal.
I tell us
We
impugned order.
hear from you itself that letters patent appeal not maintainable. Issue has not been finalized by
I
the
tell you, lawsuit, learned single judge pointed, Malad, noted that we raised the point of maintainability.
Yes.
Then your lawsuit, if I take a Jamara point in the writ petition, that this should not be entertained. So that should be decided fast.
127 appeal is a bar to the writ petition, was not considered at the interim stage. You are right. Because the court was of the opinion that alternative remedy is not a bar. That is why the
Malad,
court
that's not the learned judge has said it.
that line is not there, but he has recorded
Then
your
lawsuit,
statement.
then your lawsuit, learned single judge has to record the reasons why not barred.
Yes.
That's not recorded, your
But
lawsuit.
what other judgment, Mr.
Other judgment, your lawsuits. Malad, this is a paragraph. Malad, your lawsuit, this is Malad 2012 2SCC page 108. This is
এইখান থেকে বলছে সেকশন 126 এর এটা দেখো প্যারাগ্রাফ 22
no.
সীতারামটা লিখে
Yes, paragraph.
I just give you loss. Malad, page 7, paragraph 77. Under the procedure prescribed, the person has to be served with a notice inviting to file objections, if any, within the stipulated time in terms of section 126(3), and the assessing officer is required to pass a final order within 30 days from the date of service of such order of provisional assessment. If the consumer doesn't pay the provisional assessment amount as required under section 126(4) and file objections under section 126(3), and then after affording opportunity to the consumer, the assessing officer shall assess the amount and pass an order of final assessment as stated in section 126(5). Section 126(6) contemplates the assessment under section shall be at a rate such and such. Malad, I am not then. Once the order of assessment is finally served and served upon the consumer, he is expected to pay the said charges unless, being aggrieved from such an order, he prefers an appeal under section 127.
No, Mr. Sannal, where are these questions 2 and 3? That is in which paragraph?
I just give you lawsuits. That was framed your lawsuits, the entire.
Expected. He's expected.
No, question number. The issue frame করেছিল Supreme Court. I just give you lawsuits.
Is that paragraph 15?
I just, Malad, I have missed one thing. That's why I'm little Yes, my lord, paragraph, no. That's not, your lordships.
Paragraph 12. Yes. It's that whenever it
Yes, madam. Paragraph 12, questions for determination.
so far, these are answers to two questions.
Whether the High Court in the facts was justified in interfering with the provisional order of assessment in exercise of jurisdiction. Was the writ petition before the High Court under Article 226 Constitution not maintainable because of?
Yes.
Now your losses will find the last paragraph 78. Once the order of assessment is finally passed and is served upon the consumer, he is expected to pay the said charges unless being aggrieved from such an order. He prefers an appeal under section 127(3) of the Act. The appeal under section 127 would lie only against the final order passed under section 126, and that too within 30 days of the said order. And the appeal shall be filed and maintained and dealt with in accordance with the procedure specified in section 127 of the Act. A bare reading of the provisions of section 127 shows that it is the final order made under section 126 which is applicable under section 127.
Yes.
In other words, issuance of notice of provisional order of assessment may be made by the assessing officer in terms of subsection 1 to section 3 of the 126 would not be an order against the or which an appeal would lie. Then your lordships, kindly my lord, the 80. It is settled canon of law that the High Court would not normally interfere in exercise of its jurisdiction under Article 226 of the Constitution of India, where statutory alternative remedy is available. It is equally settled that the canon of law is not free of exceptions. The courts, including this court, has taken the view that the statutory remedy, if provided under a specific law, would impliedly oust the jurisdiction of the civil court. The High Court, in exercise of its extraordinary jurisdiction under Article 226 of the Constitution, can entertain a writ or appropriate proceedings despite availability of an alternative remedy. This jurisdiction the High Court would exercise with some circumspection in exceptional cases. Now, your lordships, I'm against my these jurisdiction, your lordships got it.
Paragraph 80. Last year it
after the dotted line, the 3 lines, then your lord, these jurisdiction, the High Court would exercise with some circumspection in exceptional cases, particularly where the case involves a pure question of law or virus of an act or challenge. None of these points are involved. These class of cases we are mentioning by way of illustration and should not be understood to be an exhaustive exposition of law, which in our opinion is neither practical nor possible to state with precision. The availability of alternative statutory order by itself may not operate an absolute bar for exercise of jurisdiction by the courts. It will normally depend upon the facts and circumstances of a given case. The further question that would inevitably come up for consideration before the court, even in such cases, would be as to what extent the jurisdiction has to be exercised. Should the courts determine on merits of the case, or should they preferably answer the preliminary issue or jurisdictional issue arising in the facts of the case and remit the matter for consideration on merits by the competent authority? Again, it is somewhat difficult to state with absolute clarity any principle governing such exercise of jurisdiction. It will always depend upon the facts of a given case. We are of the considered view that the interest of administration justice shall be better served if the cases of the present kind are heard by courts only where they involve primary question of jurisdiction and the matters which go to the very root of jurisdiction and where the authorities have acted beyond the provisions of the Act. None of these have been alleged to your lawsuits. It is, then your lawsuits will find some of the point has been raised, and then your lawsuits. Then paragraph 85 is all that your losses. Then here your losses.
Yes, what do you say?
Lordship, this is the best example of this case that Lordship alternative remedies cannot be about.
First, you explain why you slept for 1 year, which Mr. Sannal is saying.
Lordship,
2 year almost.
Assessment order was in July 2023. Writ petition filed in 2025.
Lordship, kindly come in the pleadings that specifically I have stated that petitioner was in regular touch with the CSC authorities.
So she will not make a representation. How we are to accept that she was in regular? That is a line statement in paragraph 13. When did you get the pro forma? When were you asked to go? Some details has to be there.
Lordship, this is the pro forma has been given by the CSC authority, Lordship, which I have stated in my pleadings.
When?
Forma for installment.
Yes. But Lordship, this here in this instant writ petition, I have challenged 2 grounds. First of all, this is absolutely violation of natural justice. Second is that the records prima facie is this final assessment order prima facie is wrong. Now, Lordship, first of all, kindly come to 126, the definition of the assessing officer.
No, why? Assessing officer was not there when it was disconnected.
No, Lordship, kindly come the definition of assessing officer.
আবার কোথায় definition? That Mr. Sannal has said.
No, Lordship, kindly come the definition of the assessing officer.
In the writ petition, what about my, I don't know what my learner will submit. There is no whisper about that.
No,
No,
in one paragraph he has said report of respondent number 2 on the basis of which it
That's your logic. That's not he's saying assessing officer.
respondent number 2 is not the assessing officer.
Respondent number 2.
Kindly come the definition.
Let my learner make it.
Kindly come the definition of assessing officer. Also, let me read. The assessing officer means an officer of a state government or board or licensee, as the case may be, designated as such by the state government. So this is the another.
কোথায় পড়ছে? মহা মুশকিলে পড়েছে।
126 definition of assessing officer.
126.
Yes, section 126.
So that is assessment.
No, lots of kindly come explanation.
Explanation to yes for the purposes of this section. Yes, assessing means an officer of a state government.
Yes.
পচা বই দিয়েছে সব। আমাদের নতুন বই আছে। We have new books. All rotten books you are placing. Yes. 126 explanation. Yes. Assessing means
Means
an
an officer of a state government or the board of licensee, as the case may be, designated as such by the state government. So, Lordship, assessing officer is the person who assessed. Lordship is not before your lordships. Not a single affidavit has been filed from the
He is
honorable.
a member of the same family. He belongs to Mr. Sannal's family. Assessing officer.
No, Lordship, this is a separate officer, is under the state government. No, designated by the state government. He cannot be an employee of a CSC.
So you are meaning to say the assessing officer has accepted the order?
Assessing officer till date has not neither filed an affidavit stating that this was a clerical mistake. Instead of 7th, it has been recorded as 5.
Respondent, which one you are saying?
Respondent number 3.
3 is the assessing officer.
3 is the assessing officer.
Yes.
Who is not a CSC.
He is a government employee.
He's a government employee.
He is not there as an appellant.
Now, Lordship, how the assessing officer's version, they can be stated in this appeal. This is the version of the assessing officer. Ought to have been. They have come with this affidavit.
Assessing officer is not an appellant before us.
Yes.
So can it be said that the assessing officer has accepted this order?
Obviously.
That's what.
Even there is no corrigendum. Lordship, kindly record that there is no corrigendum to that effect.
Corrigendum to what?
Corrigendum to that effect that this order which has been recorded as 5, 7th, it will 5, it will be instead of 7, it has been recorded as 5.
Where?
Kindly come to the final assessment order.
Yes, instead of 7, it has been recorded as 5.
It's 5. There is no corrigendum to that effect. This order was passed on 5th June 2023. Now, Lordship, when this was according to the CSC appellant that it is a clerical mistake. This is not a clerical mistake. Intentionally, Lordship, the order was passed on 5th June 2023, but the hearing was conducted on 7th June 2023. So, Lordship, when this assessing officer has not come before your Lordships or before the Honorable Single Judge, say, now this is a wrong mistake on our part, the CSC authority cannot take the burden on behalf of the assessing officer.
No, that mistake on a part that was stated before the learned single judge.
No.
Did they say that it was a mistake on our part? There was one line of his lordship.
That is the CSC, but not assessing officer, nobody is appeared. CSC officer, the respondent CSC cannot represent the assessing officer in terms of definition of the assessing officer.
All right. Yes. Next.
Now, Lordship, this order of final assessment order, prima facie is wrong because kindly come to the inspection report which was supplied at the time of delivery of the provisional order.
Page 48.
Let's kindly come. Provisional order starts from page 45.
তারিখে অর্ডারটা দিয়ে থাকে তাহলে ও রেকর্ড করবে কি করে এটা না রেকর্ড করবে কি করে 7 জুন হেয়ারিং
Yes.
Lordship, side by side, I am relying upon 126 subsection 1. This provisional assessment order has to be passed based of my judgment.
Of the
Now,
assessing.
of
the assessing.
126 subsection 1. Lordship, know that. Lordship, I am not giving trouble to read. Now, Lordship, kindly come the provisional assessment order at page 45.
45.
Yes.
Yes. Yes.
Lordship, I'm just reading. Prepared as report on my such inspection at site, a copy of which is enclosed. Lordship, got it?
Which paragraph? Prepared a report. Yes.
Yes. Now, this is a report has been enclosed. Whatever the inspection report has been enclosed. Now, it has been served, has been taken during the inspection. Copy of the copies are taken and enclosed. Provisional assessment to the best of my judgment. The charges for unauthorized use of electricity to the tune of rupees such and such give electricity duty as applicable payable to the state government as per details indicated in the attached calculation sheet. Now, Lordship, are entitled to file a written objection together with the copies of all documents and records and material as you may like to rely upon by me against the order of provisional assessment order within a period of 15 days from the date of the order of provisional assessment order. Now, Lordship, kindly come the inspection report at page 48. So, Lordship, this inspection report he has relied according to this provisional assessment order, and this has to be best of his judgment. Kindly come page 48. How this is prima facie on the face of record, it is illegal. Direct connection found from the CSC's incoming service cable come bypassing the metering arrangement, and during the inspection from the load found 27.3 ampere, but while taking the photographs it appears to 5 ampere. So, Lordship, it's the load was taken which was prima facie is a 5 ampere.
Yes.
Now, Lordship, the bottom, the unauthorized supply of electricity was being distributed to surrounding area and such and such and such. This was also allegation in the inspection report. Now, Lordship, kindly come for the provisional assessment order, that is page 49. Lordship, higher contractual inspection load, that is 27.27 6 kilowatt, that is 27 ampere. 6 kilowatt equals to 27 ampere. Now, Lordship, this amount they have calculated 5 lakh, whatever the amount, on the basis of the Lordship, that is 6 kilowatt, that is 27.3 ampere. So, Lordship, they have on the inspection report, it appears that the load was only 5 ampere, whereas consumption was 5 ampere, whereas they have calculated the provisional assessment order on the basis of 6 kilowatt, that is 27 ampere. Now, Lordship, from this final assessment order, now there is not a single word that this was the taken, at the time of inspection, 5 ampere was the consumption. Lordship, they have taken 27 ampere. There is no such, Lordship, the grounds was taken that why we have taken 27 instead of 5 in the final assessment order.
Yes.
Kindly come page 50. This is the final assessment order. The connected load at the time of inspection was established on 6 kilowatt and the contractual load was 5.80 kilowatt. Since the connected load was higher than the contractual load, connected load has been considered for the assessment by the relevant schedule of the regulation of the West Bengal Electricity Regulatory Commission. That's a period, lots of this is the period, not for load factor is not. I passed the firm an order of provisional assessment order on 24th May 2023, wherein inter alia sum of rupees such and such was assessed.
You read, it was their statement was during our inspection, tong load found 27.3. At the time of inspection, it was found to be 27.3. Then, but while taking photographs, it drops to 5 MP.
How can?
That is your
This is the consumption.
You were diverting the load for supply of it cannot be totally ruled out, Mr. Mukherjee, that you were diverting the load for supply to others.
So kindly see any of the single line from this final assessment order that due to this reason,
Page 48. The unauthorized supply of electricity was being distributed to the surrounding area.
Now this grounds, this load, which was contract load 5.8 horsepower, which was dropped to 5 HP, that has to be considered by the assessing officer. Kindly see from the final assessment order, nothing has been considered.
Yes, what is your next point? Anything else?
There is no explanation in the final assessment order.
All right, yes.
Kindly come. I passed the order of final assessment on 24th May 2023, wherein inter alia sum of rupees was assessed as claim towards the unauthorized use of electricity and electricity duty payable to the state government.
Come to the next page. You have alleged that they have alleged that you have admitted the unauthorized.
No, they absolutely false.
So when it was communicated to you on 15 June, why didn't you say any single statement? This order was received by you on 15 June. You never said that, sir, you have put the date as 5th June or I have not admitted anything. You are arguing these points before us now. So not a single document, Mr. Mukherjee, that there was a error. There was, you have not taken that 27. Even if he is an illiterate lady, she was present now with a person with his choice. It becomes difficult to believe your version.
Now let's say final assessment order in terms of section 126 subsection 4.
Yes.
Is reached to the finality.
Because
Lordship,
you
there is
will-
no provision of review or recalling by the assessing officer. There is no power.
No, your that is the judgment Mr. Sannal is relying.
That is,
That
Lordship,
writ court gives you the liberty to go back and challenge by condonation of delay.
now Lordship, this is, first of all, kindly come again 126, subsection 3.
আমার বক্তব্য হচ্ছে 23 থেকে 25 তুমি বেটা ঘাপটি মেরে বসেছি কি করো আমি এইটা কোনোদিন এটা তুমি তখন বললে না কেন? বেশ, তুমি অ্যাপিল ফাইল করতে জানো, তুমি 23-এ রিটটা ফাইল করলে না? বসে
Yes, anything else?
Now, Lordship, kindly come. The assessment which has been done by the assessing officer is also not in terms of regulation.
Yes.
Lordship, the assessment which has been done by the assessing officer also not in terms of the regulation 2030.
The present appeal has been preferred.